And this is for 2870 East Allegheny Avenue. Appellant is Riverside Materials, Inc. And this case has been withdrawn.
Okay, thank you. Withdrawn.
Next, we have case number 8, appeal number HA-2021-001630, Donetta Holmes for 4935 Chestnut Street. This case has been withdrawn.
Withdrawn, thank you.
We have case number 17, appeal number HA-2021-002295, Ruslan Niken. Address is 2419 Sharswood Street. And we have a continuance request for after August the 10th.
Okay, who's representing the city on this matter? Who's representing the city?
Hi, sorry, board. This is Noah DeSimone. I'm a certified legal intern with the city. I'm going to be the one speaking for this appeal.
Okay, there's no counsel assigned to this matter?
我现在不能讲了，我在 court meeting。
Mr. DeSimone, is no legal counsel assigned to this matter?
Yeah, I'm technically the counsel. I'm an intern working under an attorney for the city.
Sorry, Chairman Woodson. I am the attorney that's assigned to this matter.
And you are?
Mary Costello.
Okay, that's what I want to hear from. Thank you.
Okay.
This matter has been a continuous request. I want to get you to say this response.
And I just want to confirm this is for number 17.
Yes, that's correct.
Okay, so this matter is actually moot complied.
Okay, thank you very much. Thank you.
And Chairman Woodson, can I just clarify with you that Noah is a certified legal intern, and because of that, he is also considered counsel, just for the record.
Okay, already. He has authority to speak on behalf of the law department?
He does, yes.
Okay, all right, that's good to know. But I prefer to talk to the lawyer assigned to the case.
Okay,
Thank you.
thank you.
Next case is, we have case number 18, appeal number HA-2021-002301 for Kelly Shock, 1830 Fulmer Street, and that appeal has been withdrawn.
Withdrawn? Okay, thank you.
We have case number 25, appeal number HA-2022-001546 for Wade Seriani, 2833 Maxwell Street. We have a continuance request.
Okay, that matter is continued in executive session.
Yeah.
I'm sorry to interrupt. Hi, this is Althea Udowinyang, attorney for the Philadelphia Water Department.
Yes.
I just sent, this matter has been settled.
Oh, it has?
The board over, I just sent over the signed settlement agreement, emailed maybe less than 30 minutes ago. The agreement was city affirmed with 120-day stay of enforcement.
Okay, so that's an agreement that you worked out with the appellant, Mr.
Correct.
Wade Sirianni?
Yes.
Okay, so you need the board to confirm that.
Yes, please, at the
It's
appropriate.
120-day stay of enforcement?
Correct.
Okay, all right, we will then poll the board on this matter regarding HA-2022-001546, Wade Sirianni, 2833 Maxwell Street, as per the agreement between the parties, 120-day stay of enforcement. City affirmed.
City affirm 120-day stay of enforcement.
City affirm 120-day stay of enforcement.
City affirmed 120-day stay of enforcement.
City affirm 120-day stay of enforcement.
Thank you very much. Okay, what do we have next?
We have case number 30, appeal number HA-2021-002613, Don Inc., 1700 West Allegheny Avenue, represented by Attorney Jake Griffin. We have a continuance request.
Okay, let me hear. from
Morning,
the
Mr.
city.
Woodson.
Yes,
Good afternoon, Mr. Woodson.
good afternoon.
As I explained in an email yesterday, I had just received notice of this yesterday by the client. An email notice had mistakenly gone out to previous counsel. So I had not gotten notice. I communicated with City Council Amy Skiles. There are two other matters that are all sort of jointly related. They've all been together. They're currently scheduled for August the 9th. And both Ms. Skiles and I would respectfully request if you could move this one to August the 9th.
Okay, is Ms. Skiles, are you present?
Yes, good afternoon, Amy Skiles on behalf of the
Yes.
city. We are in agreement. We have no opposition to the date today to move this case to August 9th to be heard with the others.
Okay, that's fine. Then we'll continue. We'll note the record that is continued and will be listed August 9th with other matters that are related. So,
Okay,
Okay, thank you.
just so I can put on the record, we did send notice to Mr. Griffin. We mailed it to him. We did not send it to him electronically.
okay, all right, thank you. So the record is clear. All right, thank you very much. Anything else, Ms. Alfred?
Yes, we have case number 33, appeal HA-2021-004647, Jason Qatar, 1312 Durant Street, represented by Robert B. Monter, Esquire, and we have a continuous request from the attorney.
Okay, who's representing the city in this matter?
I am Chairman Woodson, Mary Costello on behalf of the city.
Yes, do you have a position on this request? This continues.
So we would agree to this request. This is a complex matter that involves the permanent revocation of a contractor's license to work in the city of Philadelphia. And we do have 4 witnesses that we would like to appear, but it became clear yesterday, a witness that we thought would be able to appear today is now a hostile witness and he will need to be subpoenaed. So we agreed to their continuance request and would make our own if they had not.
Okay, okay, now, is this contractor currently working or is he currently on a suspended status?
I mean, I also have Will Fernandez here from the AIU department. He can speak on this matter as well. I do not believe that he is currently working. There's nothing that says that he cannot work at this time, but it is not my understanding that he
Okay,
is.
well, let's before we get into other, I don't want to bring any other witnesses in this, so I'll accept your request for continuance. That's probably the easiest thing to do.
Okay,
We'll continue the matter. Okay, thank you.
thank you.
Thank you, Chairman.
Okay, have a good day.
Thank you, members of the board.
Is Mr. Monter present? I just want to see if he's present so he understands what we've done. I guess he isn't present. Okay, thank you. And do we have anything else?
Yes, we have number 35, appeal number HA-2022-002662, Bartlett C. Clark for 2326 Reed Street. We have a continuance request.
Okay, this is an intent to cease, so who's representing the city?
Hi, this is Christopher Johnson for the city of Philadelphia.
Yes. Mr. Johnson, an intent to cease is a serious matter. So I want to get your take on this this continuance request.
Well, the city is opposed to continuing it. This was an appeal of a intent to cease order. The cease has not gone into effect, but I know that there's a shared living situation in this single family dwelling where there may be up to and exceeding 11 occupants. And I would like to hear from Inspector Alvarado, who's been inside the place, to assess whether there's life safety issues that would be impacted if the city does not impose the cease.
Okay, let's do this. Is there anyone here representing that address, 2326 Reed Street presently? Okay, what we will do is we will
I think
call
Mr. Clark is on the call.
Bartlett C. Clark is on the call?
He's muted.
Okay, can we unmute Mr. Clark, please?
I asked him to unmute.
Yes, I'm present.
Mr. Clark, what is your request, the continuance request about? What's the reason for the request?
I'm trying to get a little more time here because I have occupants in the property. This is not a normal occupancy. This is a recovery house. I have occupants that really have no place to go. I'm in the process of being licensed by the state, which the state informs me that they have an agreement with the city to waive the zoning for recovery houses.
I'm not, let's do this. Mr. Clark, are you incorporated?
No, sir, I have an LLC, but the property is under my name alone, not under
Okay.
the.
Well, let's do this. We're going to proceed with the hearing today. We're not going to continue it. So prepare yourself to put your case on.
Yes, sir.
Okay. And the intent to cease is too serious a matter to continue out into the future. Thank you very much. All right, Ms. Alfred, do you have some additional matter for us?
Yes, I have two agreements that I wanted to read on the record as well.
Okay.
Back up to number 4, case appeal number HA-2021-001362, Jose C. Ladge, and the address is 901 East Cayuga Street. We have an agreement in place.
Okay, who's representing the city?
Chairman Woodson, Mary Costello on behalf of the city.
Okay, Ms. Costello, what's the nature of the agreement?
The agreement, it's a stay of enforcement agreement, I believe, for 30 days.
Okay, city affirmed?
City affirmed.
Okay, all right, then, thank you. So we will then poll the board with regard to HA-2021-001362, 901 East Cayuga Street, Joe Jose C. Large, city affirmed, 100-day stay of enforcement per the agreement.
Mr. Chair, I think you're correct. It was 30 days, I believe, Mr. Chairman.
30 days, my apologies.
Am I correct, Ms. Costello?
Yes, let me just make sure that that's what he stated. I believe it was 30 days.
Okay, my apologies. We'll correct the record then to read city affirmed, 30-day stay of enforcement as per the agreement between the parties.
City affirmed 30-day stay of enforcement.
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 Thank you very much. Okay.
And we have one more agreement.
Okay.
This is case 34, appeal number HA-2022-002584 for Alvin Smith, 1511 West Lehigh Avenue, and we have an agreement in place.
Okay. Who represents that matter?
Chairman Woodson, this is me as well, Mary Costello on behalf of the city of Philadelphia.
Okay. And what is the agreement?
This is a 90-day stay of enforcement agreement.
Okay. Is city affirmed?
City affirmed.
Okay. Thank you very much. We will then poll the board with regard to HA-2022-002584, Alvin Smith, 1511 West Lehigh Avenue, city affirmed, 90-day stay of enforcement per the agreement.
City affirmed 90-day stay of enforcement.
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 Thank you very much. Okay. I think that's it. Ms. Albert, we have to make a correction on the record regarding the listing cases today.
Yes, I just want to put on the record that we have two number 32.
Some people like a generator. You probably don't need many though.
We'll need to remute some people before you say that. Yeah, there you go. Thank you.
I just want to bring on the record that we have two 32s and two number 33s at the end of the list. After the first number 33, it should be number 34, which is HA-2022-002584 for Alvin Smith, 1511 West Lehigh Avenue, and we already have a city affirmed 90-day stay of enforcement. And the next case, the last one, should be number 35, HA-2022-002662, Bartlett C. Clark, intent to cease for 2326 Reed Street.
Okay, thank you very much. Okay.
Ms.
And,
Alfred, if I may, Jake Griffin, I sent you an email. I also have a request on another matter I'm handling, so I'll wait until you get to that.
Yeah, what will happen, we'll now ask each of the attorneys representing the city if there are matters that they have resolved in some fashion that may in fact incorporate your request, Mr. Griffin. So we'll wait and see what happens.
Good afternoon, Chairman Wilson, if I may.
Yeah, I'm prepared now to call the roll. So just give me a moment, okay?
I just want, my comment is in regards to the city's moot and compliant matters for today's list.
Yes, I haven't called them yet. That's what I'm about to do.
Yeah, I just wanted to make note before the board that the city has 2 certified legal interns today, Noah DeSimone and Caitlin Carmody, who are authorized to represent the city before the board regarding these matters. And our interns will be reading into the record our moot and compliant cases.
Just the moot and compliant cases?
Yes.
Okay. That kind of thing I need to know right before we start. No disrespect to them, but I also have to make sure that we're running smoothly and listening and hearing from counsel for the city. Okay?
Yeah, so Ms. Carmody will be reading the first half of our.
But I haven't called on you yet. When I call on your name, she will then speak up. Okay?
Yes.
Okay, thank you. Alrighty, now we're going to see who else is here so we can get things on the way. Ms. Udo Inigwe, Alethea, any requests that are continued, withdrawn, or otherwise resolved?
There was number 26. It was previously withdrawn, 1003 Watkins Street, last 1548.
Okay, that's HA-2022-001548.
Correct.
We'll note that it's withdrawn. Thank you.
That's it. Thank you all.
Okay. Ms. Costello, you have anything else that was continued or otherwise withdrawn?
I do, Mr. Woodson. Number 15, HA 2021-001986. It's Joshua Hyman's appraisal license. That is moot complied.
Moot complied, thank you.
Yes.
All righty.
And that is the only matter I have.
Okay, thank you. Christopher Johnson.
Hi, I only have 2326 Reed Street. It's number 35 on the list. That's my only case.
Okay, but is that continued or withdrawn or otherwise resolved?
No.
Oh, okay, that's all I want to hear about at the moment. Okay, Mr. Roder.
Good afternoon, members of the board. Leonard Reuter, or EUTER, for the city of Philadelphia. I have one continuance request that's joint and one moot complied.
Okay.
I'll do the moot complied first. It's number 31 on the list, appeal number HA 2020-002685, Francisville Neighborhood Development Corporation. And that's again 1630 Ridge Avenue. Mr. Orphanides is here representing the appellant, but we made a determination today that it is moot complied. And one of the interns actually would have put this into the record, but we literally just got confirmation of that about 15 minutes ago. So.
Okay, thank you. And you have one additional?
I have a joint continuance request for number 23 on the list, appeal number HA 2022-002328. Brian Julia and Jeanette Rolling Julia. It's an appeal regarding 536 Green Lane, and Mr. Griffin is here. This involves a violation for operating a dance studio without a use registration permit. There is actually a request for a variance that was made to the zoning board. That matter has now been appealed to the Court of Common Pleas, and that case is still open. I think argument is sometime in August, and then it could be anywhere from a couple days to a few weeks after that the court would issue a decision. So we will agree to a continuance of this matter for what Mr. Griffin wants. I would say at least 90 days.
Okay. All righty. So
I concur, Commissioner. Yes, sir.
Yes, okay, Mr. Griffin, this is the joint request?
Yes, sir.
Okay, and late August, early September, Mr. Rowdy?
I would say probably late September, because sometimes the court can take up to a month to issue a decision.
Okay.
So yeah, I would say at least the end of September.
Okay,
6
so
to
we'll
9.
continue.
concur.
that. Okay, thank you.
Thank you,
very
sir.
much.
You're welcome.
And
Thank you, Leonard.
Thanks, Jake. Take care. And I have 2 other cases that I'll go forward.
Okay, thank you. Ms. Desiree Davis, and you have an intern who will speak for you, I believe.
Yes, good afternoon, Chairman. I don't have any matters. The interns will take care of the rest of the moot and complied cases on the list.
All right, thank you.
Hi, good afternoon, members of the board. My name is Caitlin Carmody. I am a certified legal intern for the city of Philadelphia. I have a few matters, beginning with number 2 on the list. This is appeal number HA 2021-001083. This concerns a vacant structure license, and the city is withdrawing this violation as it was written in error.
Okay, withdrawn. Thank you.
Next, number 5 on the list, appeal number HA 2021-001387. This concerns a use registration permit. This case has been moot complied.
Moot complied, thank you.
Number 6, appeal number HA 2021-001409. This concerns a rental license. This case has been moot complied.
Moot complied, thank you.
Next, number 7, appeal HA 2021-001553. This concerns property maintenance, and the city is withdrawing because the property has been sold.
Okay, thank you. Withdrawn.
Number 10, appeal HA 2021-001668. This concerns a rental license, and this case has been moot complied.
Thank you. Moot complied.
And lastly, number 11, appeal HA 2021-001973. This concerns a vacant structure license, and this case has been moot complied.
Moot complied. Thank you very much.
Thank you, Mr. Chairman.
Okay. All righty. Let's see here. Mr. Cohen, Jeffrey Cohen.
Good afternoon, members of the board. I am here on behalf of the city for matter number 20. As far as I know, there is no continuance request, no mootness.
Okay.
This should be a ready matter.
Thank you.
Thank you.
Okay. We have a large group today, so I'm going scrolling through my pages. Just be a little bit patient with me. Okay. Ms. Maggie White.
Good afternoon, Chairman. I'm actually just observing, and I believe that Noah DeSimone, the other certified legal intern, will read the rest of the city's moot complied cases.
Okay. Already. Ms. DeSimone.
Good afternoon again, board. Noah DeSimone, certified legal intern with the city of Philadelphia. I have 5 matters, all moot complied.
Okay.
The first is number 12 on the list. This is appeal number HA 2021-001974. That is moot complied.
Okay, moot complied. Thank you.
The next matter is number 14 on the list. This is appeal number HA 2021-001984. Again, this is moot complied.
Thank you.
The next matter, 15 on the list. This is appeal number HA 2021-001986. Moot complied.
Okay.
The next matter is number 19 on the list. This is appeal number HA 2022-002695. Moot complied.
Moot complied. Thank you.
Yep. And the last matter, number 32 on the list. The appellant is Alice Woodson. This is appeal number HA 2020-003778. Moot complied.
Moot Move compliant. Thank you very
Thank
much.
you. Thank you, board.
Okay, ready? And I assume that exhausts our list of continued requests to move compliant, otherwise resolve matters. And before we call our first case, let me then welcome, I didn't realize you guys would be doing this today, but welcome to all the certified legal interns. I hope that this will be a learning experience for you, that you will become at some point licensed to practice in the state of Commonwealth of Pennsylvania. And so in the meantime, pay close attention to what we're doing. And I will be calling on the individuals whose name I recognize until I get to know you. Okay, thank you. Let's then go back up to the top of the list. And,
Chairman, it's Amy Skiles on behalf of the city. I do have one
oh, you do? Okay.
additional, it's a joint continuance request number 24. It's an intent to cease. However, there's been significant progress to comply these violations. So
Okay.
the city has agreed to a 60-day stay of enforcement while the violations continue to be complied. And so we would be requesting a continuance, about a 60-day date as well.
Okay, now, is there anyone representing the appellant present?
Yes, I believe I did see Mr. Marcial on the call
is-
earlier.
This is Henri Marcial, and I represent the appellant in the matter.
Okay, sir, would you spell your last name, please?
My last name is spelled Marcial.
Okay, your legal counsel for the Seth Floyd?
Yes, the property is under the name of an LLC, Porter Brothers LLC.
Okay,
Seth Floyd is the managing member.
okay, so Floyd Brothers LLC? Okay, all right, thank you. And you have, this is a joint request between the city and Ms. Skiles. Now, is that an affirmative decision by the board or just a continuance request?
We would, a continuance request.
Okay, all right, thank you. We'll consider this a continued matter then. Thank you very much.
Thank you very much.
Okay. All ready?
Another continuance request, please.
And you are? Someone just speak up?
Commissioner, can you?
Not very well. You're breaking up.
Aaron Boyd, at the.
He has a very bad connection.
Yeah, your connection is poor, sir. We can't hear you.
Can you hear me now?
That's a bit better. Which case are you calling about?
Aaron Boyd.
That's number 10.
Okay. Number 10. Are you
Aaron Boyd?
What is your relation? Are you the legal counsel for Mr. Boyd?
I'm the counsel for Mr. Boyd, correct.
That case was moot complied.
Yes,
sorry?
we read it into the record already. It's been resolved as moot complied.
Oh, it's been complied. Okay, I apologize. Thank you.
Okay, you're welcome. Thank you. There's nothing else? Ms. Alfred, would you call our first case?
Yeah, we're going to do number 13.
Okay.
Okay, this is case number 13, appeal number HA-2021-001977. The Greater Bustleton Civic League. The address is 1 Red Lion Road, and they're represented by David Orfanides, Esquire.
Okay, who's representing the city?
Good afternoon, members of the board. Leonard F. Reuter, REUTER, Senior Attorney for the City of Philadelphia.
Okay.
There's also, I believe, an intervening appellee, Revelta, I always get the pronunciation wrong, represented by Michael Phillips.
Okay.
Good afternoon, members of the board. Michael Phillips on behalf of Relteva LLC, the property owner at 1 Red Lion Road.
Okay. Mr.
and
Phillips,
we've
would you
also-
mind spelling the company's name clearly? Because I just want to make sure the court reporter has that spelling down.
Certainly. Relteva is R-E-L-T as in Thomas, E-V as in Victor, A.
Relteva, okay. Alrighty.
And I also just wanted to note for the board's record that in February, we did file a motion to quash this appeal.
Okay, well, we'll get to that in a moment. I just want to make sure I have all the parties present before we start. Also, Mr. Orphanides, are you present?
Yes, sir.
Okay, thank you. I didn't see your image.
Good afternoon.
Okay. Good afternoon. All right. And Mr. Rauter. Mr. Rauter, I know there are some significant issues resolved regarding this, but I want to begin with two matters that I want the city to respond to, and then we will determine how far into this case we get today. Number one, there's the issue of standing for the Civic Association. I don't know if that's something that the city is concerned about, but it struck us as being an issue. And the second, there's a recent common pleas court decision that we just saw today, and whether that renders the whole thing moot.
Well, I mean, again, obviously, opposing counsel will have different points of view on this, as will the intervening appellee counsel. The city has not taken a position on the standing of Greater Bustleton Civic League to take this appeal. Their standing was raised as an issue at the zoning board. It was not raised specifically by the city, but it had been raised by counsel for the appellee at the time. And it was also again raised sua sponte by Judge Coyle in the appeal from the zoning board case. And while she didn't specifically say that Bustleton Civic League did not have standing, there were some concerns raised. But again, the city's taking a neutral position on the standing of Greater Bustleton Civic League. We will let Mr. Phillips raise that if he wants. However, with respect to the, and I just actually, let me just back up on the standing issue. With respect to a zoning matter, in order for this project, this involves a rather large project for a proposed United Parcel Service distribution facility up in the far northeast. And because of the scope of the project, it had to go through Civic Design Review. So Civic Design Review is a process that involves the Civic Design Review Committee, which is made up of partly of members of RCOs as well as members of the Planning Commission. The RCO that is actually for which this particular property is part of the boundaries of the RCO, for various reasons, did not participate in the CDR, but Greater Bustleton Civic League did meet with the developers for the CDR. However, Greater Bustleton Civic League's boundaries actually do not encompass the property at issue. That's kind of like is a total thing by itself. But again, because the meeting with RCOs or some kind of community meeting was required as part of the CDR process, and Greater Bustleton League was not actually the RCO that covered this property. That's, I think, why the issue was raised in that context. This is a building permit that is being appealed, the issuance of the building permit that's being appealed. And again, we do agree that any appellant would have to show how they're aggrieved by the issuance of the building permit. So, but again, the city's taking no position here on standing. I just wanted to explain why it was an issue in the zoning case. It might not necessarily be the same outcome here. In other words, the two things don't necessarily, how standing was resolved in that case doesn't necessarily dictate how it would be resolved here. Now, you also asked about Judge Coyle's decision. That was the appeal. So what happened was we issued a zoning permit by right. That was challenged by Greater Bustleton Civic League, as well as an adjoining property owner, Sandwire Steel, which owns a property that is adjacent to 10098 Sandmire Lane, which is a property that's being used conjointly with this property, One Red Lion Road, as part of what's called the Unity of Use Agreement that allows you to conjoin parcels for purposes of treating it as a single zoning lot. That by itself was an issue in the zoning case. So anyway, the permit was issued. Greater Bustleton and Sandmire Steel both, each them separately filed appeals from two different zoning permits that have been issued, one for the unity of use and the other one for the actual proposed use for the distribution facility. That those appeals were heard together by the Zoning Board of Adjustment, which affirmed the city, and then an appeal was taken again by both parties to the Court of Common Pleas, And after, briefing, and I believe it was a 3-hour-long oral argument at the Court of Common Pleas, Judge Boyle ultimately, I think a week or 10 days later, issued her order affirming the zoning board. So her position, her opinion affirmed the correctness of issuing the zoning permit. So to the extent that this appeal from the issuance of the building permit is premised upon a defect in the zoning permit, that matter is resolved because Judge Boyle has now entered an opinion. We understand that that is still subject to an appeal, but as of today, I'm not aware that any appeal has been filed from Judge Boyle's decision. I don't know how many more days they have to appeal that.
Okay.
2.5, 3 weeks.
Okay.
So, but again, we would say, again, to the extent that the appeal is based upon defects in the zoning permit, at least as of this moment, that issue is resolved. So that whole line of argument. But the last thing I want to point out too, and again, leaving aside the motion to quash that's before the board, just the city's position is this entire appeal, again, especially as it concerns the, to the extent it's premised upon the validity of the zoning permit, there's no purpose to this appeal. If the courts ultimately, like, let's say there's another appeal to Commonwealth Court and then the Supreme Court or whatever, but if at the end of the day a final adjudication is reached that the zoning permit is invalid, then the city itself will revoke the building permit automatically. We won't, because that would be a final decision, and the building permit, at least to a great extent, the building permit requires the zoning permit to be good. So if the court ultimately says the zoning permit's no good, we'll revoke the zoning, we'll revoke the building permit. This appeal doesn't, there's no reason for this board to address the underlying zoning question at all. The second point is that if in fact the zoning permit is, as we expect, will be ultimately upheld, it will be a final adjudication, and that may have already happened if there's no further appeal, but if there's a final adjudication that the zoning permit is good, then this board has no authority to challenge either what the zoning board decided, or for that matter, what the courts decide with the validity of the zoning permit. So everything having to do with zoning cannot be before this board. I mean, or even if it can be, there's no point to it because the zoning issue is decided by the courts, not this board. They don't get another bite at the apple on the zoning question through this appeal.
Okay.
So
thank you. Mr. Phillips, would you share your view on the standing matter as well as the court decision?
Thank you, Mr. Chair. It is our opinion, and as set forth in our motion to quash, that Greater Bustleton Civic League does not have standing and is not an aggrieved party as it pertains to the issuance of the building permit for the project. Number one, the RCO's boundaries do not include or encompass One Red Lion Road. They're located across the street, so they are not even an RCO that has a jurisdiction over this parcel of land. Somerton Civic Association would have been the correct civic association. But notwithstanding that, even if this was within their boundaries, Greater Bustleton Civic League has not pointed to a single error or a defect in the underlying building permit that would either cause them to be an aggrieved party or would give warrant or rise to this appeal. They just, in boilerplate fashion, say that the building permit was incorrectly or improperly issued or issued in error without any other formal statement. So they do not have standing on those grounds, and I'm hard pressed to see how Greater Bustleton Civic League would be aggrieved by a building permit permitting the erection of a single-story distribution and warehouse facility at One Red Lion Road. As it relates to the recent decision by Judge Coyle, the zoning matter was heard extensively over numerous hearings before the Zoning Board of Adjustment, which upheld the issuance of the zoning permits, and then on appeal to the Court of Common Pleas, which upheld the issuance of the zoning permit as being by right. to the extent, as Mr. Reuter pointed out, that really is the only basis for this appeal of a building permit. There are legal principles of res judicata that prohibit Greater Boston Civic League from getting that second bite at the apple. We have a conclusive final determination that the zoning permits were valid. And even if those are appealed, that does not invalidate the decision of Judge Coyle. It is a binding precedent until and unless it is appealed, which we are and overturned, which we are confident will not happen. So here, what we have is Greater Boston Civic League trying to take a kitchen, throw everything but the kitchen sink approach to this project and development, and unsuccessful in their efforts to appeal the zoning permit, are now filing an appeal of the building permit without any grounds, without any basis, without any specification of what the error or defect in the issuance of the building permit is. The city has stood behind the building permit and its issuance, and all this appeal is doing is preventing development and thousands of jobs in the far northeast, and that just cannot stand. So without the ability to point to any causation of harm, any aggrieved standing, or any direct immediate interest in the issuance of the building permit for the single-story building, the appeal must be denied, and Judge Coyle's ruling must be allowed to stand unabated.
Okay. Mr. Phillips, the motion to quash that you submitted is directly related to this appeal to the Board of Review, correct?
Correct.
Okay. All right. Thank you. Mr. Orphanides.
Thank you, Mr. Chairman Woodson. So on the question of standing, first of all, that question was raised and addressed in front of the zoning board in terms of the zoning permits, which underlie the building permit in question here. At the conclusion of that hearing, there was some discussion regarding that, and the zoning board held that Greater Boston Civic League had standing. That was not that decision of the zoning board. There was an appeal taken from the decision of the zoning board, but it was our appeal, and the appeal was Sandmeyer Steel. The Reltiva or UPS, so let's be clear, like the tenant here is going to be UPS. This one-story building that Mr. Phillips is minimizing is a 1 million square foot high parcel cube distribution center. It's a massive, massive installation with thousands and thousands of vehicles coming in and out every day by their own traffic reports. But that being said, they did not appeal the decision of the zoning board. The determination, neither the city nor Reltiva appealed the decision of the zoning board, finding that we had standing, that Greater Bustleton Civic League had standing. Our boundaries run directly across the street. We're right across on the other side of Red Lion Road. And as trucks are going to be coming on both sides of Red Lion Road, these thousands of tractor trailers and package trucks and passenger vehicles. And there's no doubt that we are aggrieved. Our members, the residents of our communities, the members of our community group will be aggrieved if this is ultimately approved, constructed, and begins to operate. Community organizations and its members individually are substantially, directly, and immediately threatened with harm by this proposed development, as I've said. And standing applies to organizations as well as individuals. You don't have to be an individual. Through their members, organizations may contest adverse actions by means of derivative standing, which is what we have here. And there's plenty of cases that talk about that. We have 324 dues-paying members, including 26 who live directly across the street from the primary entrance to this facility at the Island Green Estates.
Mr. Orphanides, when you say across the street, are you referencing across the 6 lanes of Rosa Boulevard or a different street?
Red Lion Road. We're near Roosevelt Boulevard. We're just to the west of it. But this property sits along the north side of Red Lion Road. and then actually has entrances or exits proposed along what's called Sandmeyer Lane, which winds around off of Red Lion Road back behind the property. It ends in a cul-de-sac where there's another parcel, 198 Sandmeyer Lane, that's part of this proposal as it abuts and is adjacent to 1 Red Lion Road. But they never appealed that decision. And Judge Coyne, and even though she kind of went on a little bit about it, did not overturn that decision regarding standing. There was no appeal. She raised it as Mr. Reuter, and there's no difference. In fact, there may be greater difference. I mean, more impact now, because before we're just talking about zoning. And as you know, somebody could pull a zoning permit and never do anything about it. This is a construction permit. If this goes through and gets built, everything that we're concerned about, and everything that they've set forth in their own traffic reports will be impacting us, and we will be aggrieved by it. So there is no doubt, and the zoning board has upheld it, the court of common pleas has upheld it. In fact, while there was a decision, which Mr. Phillips just sent to you today, less than 3 days in advance of today's hearing, if he didn't mention to you, I believe, that they submitted a motion to correct the order, for Judge Coyle to correct her order. And in that motion, I have it in front of me, I'm reading it right now. They don't even raise the standing issue in their decision on it. They raise her, the way she addressed the particular zoning overlay and that she claimed it didn't apply. But so in my mind, they're raising it here. It's been decided. They've never appealed it otherwise. And you talk about just throwing everything up and see what sticks. Shotgun approach, that's exactly what this is. And I don't blame Mr. Phillips for trying, but it's clear. And just real quickly, while we were not the designated we're not an RCO that specifically appears, his client came and appeared before our community group at a community group meeting. And our client, during the CDR process that Mr. Reuter referenced, had a seat, a virtual seat at the table with the CDR committee, which is generally reserved for the community group that they respect and take as having standing and having particular insight and to be impacted by the project. It was the Greater Bustleton Civic League, Jack O'Hara, who I have here all with me today as a witness, who was that. There's no doubt we've been recognized by everybody, including the applicant, and that we have standing in this matter.
Okay.
I would just like to quickly rebut one point that Mr. Orphanides made. Like, standing for a zoning permit is different from standing from a building permit, and the two cannot be conflated. And Mr. Orphanides is reliant on the fact that Greater Bustleton Civic League was deemed to have standing by the Zoning Board of Adjustment is far different from standing in a building permit case. For zoning matters, zoning is an exclusive precondition to the adjustment of a fundamental human relationship between the community, land, and the development of land. The issuance of a building permit is much different. This is a technical, ministerial requirement. So long as the building plans conform to the building code and all the applicable codes adopted by the city of Philadelphia, there is no discretion involved. The building permit must be issued. And to claim aggrievement or that you are a party harmed by the issuance of that building permit suggests that you must be able to point to some defect in that permit that therefore is directly related and caused to harm to you as an individual or as an entity, as Mr. Orphanides pointed out. That's absent here. So we cannot claim that, oh, well, we have standing in the zoning case, so therefore we have standing here, because the two are not one and the same. And if anything, I believe it is a much higher burden for Greater Bustleton Civic League to meet in the context of a technical review of a building permit. And again, they've essentially admitted this is our last chance. We didn't win for zoning, so now we're going to try to attack the building permit without again.
I'm going to have to object. I didn't admit to anything.
No, this is what we're going to do, because these are not opening statements for a projected trial. Mr. Orphanides, give us your position on this issue of Judge Boyd.
Her position, what position, on standing or?
No, not standing, on the matter of whether or not this matter should just be considered moot.
So there's two aspects. There's two things here. So there is an underlying zoning aspect to the building. Can you hear me?
Yes, yes.
Okay, somebody, Ronald Davis just popped up. So there is an underlying zoning aspect to the building permit, of course, and Mr. Reuter touched on that if in the end, and this isn't our last bite at this, there's appeals that are going to be taken, and Mr. Phillips himself has filed a request for reconsideration or correction of Judge Coyle's order. So that isn't even final at this point. But there is a zoning aspect to the building permit, and I understand that is winding its way through the courts right now. There's no doubt that it's going to be appealed to the Commonwealth Court, and as Mr. Reuter said, possibly to the Supreme Court. We'll see if they take it. With that being said, so you have their claims of, well, let me get back to that in a minute. So there's that zoning side of things, and that's why they're claiming res judicata, collateral estoppel, lis pendens, and I could address all that and what the implications of that are to this board. There's also the side, first of all, Mr. Phillips is dead wrong that this is a technical review. They are technical, under the Philadelphia Code, there are technical boards. And this is not one of them. No offense. You know what you're doing, but the Board of Building Standards is the technical board when it comes to building permits. This is the non-technical board under the administrative code. So there's a side of this. So I want to clarify that, but there's a side of this where our expert says in reviewing the building permit application, I think we all recognize zoning permits and building permits are different. They're called different things. They deal with different codes. There are different agencies that have preconditional review before L&I can review and issue their permits. One of those is the Streets Department. We know that the Streets Department review for a zoning permit, which is very preliminary and very cursory. We used to go over to before COVID, we go to the counter on the 9th floor, and one of the guys there would review it and stamp it, and you'd walk out in 10 minutes, 5 minutes. The review for building permits is much more extensive, far greater, particularly when it comes to streets. And now you have water department review. L&I's review is much more detailed and thorough. The submissions are much more detailed and thorough. Our expert, not only in talking about the zoning issues, but our expert can say that based upon the information that we have, and I'm going to get to that as well in a minute, that there was a mistake that was made, that you put what in, what comes out. And in this case, what you had is, and this is in the review for the building permit, you had information that was incorrect, that was put into the Streets Department, that the Streets Department reviewed and accepted, that in our opinion should not have been accepted. It has nothing to do with the zoning, has nothing to do with the underlying use. It's with the methodologies that they used to come up with their traffic counts and their traffic information, which served as a basis for the Streets Department to issue their prerequisite approval, which was necessary for L&I then to issue the building permit. They're completely separate things. And as such, there's an aspect of this appeal. There's an aspect of this appeal that has nothing to do with the zoning side of things. The zoning side of things is that we're questioning whether or not the use that they applied for, that they said they were going to, how they were going to use this property. Number one, some of the uses don't even exist in the zoning code. And number two, and that's what's winding its way up through the courts right now, is those uses are not what they're actually doing by their own admission through their CDR submissions, their CDR presentations, and other communications and information we just know about these types of installations. So you're left with, you have the technical side, or Mr. Phillips wants to call it the technical side, but the non-zoning side. And then there is this underlying zoning issue, and Mr. Reuter has addressed that. However, there's this dilemma that you have as the board or anybody that's considering this, is that if you were to find res judicata or collateral estoppel or lis pendens, which I argue don't exist here because they're not the same causes of action. One's a zoning permit, one's a building permit. They're not the same identical issues. So if they fail on the threshold, you'll notice in their motion to quash, they don't set forth all the 4 criteria for the basis for granting or finding res judicata. That's because it doesn't exist here. But even when you find, if you were to find it exists, you were to find that there was a final judgment or final adjudication, final decision, and find here. The problem is, and it's been recognized, what happens if that other matter that may have been decided that it was finally adjudicated, it was a final decision, which is debatable, is overturned on appeal. And to that, we did some research and we looked at this restatement second of judgments, section 16. And what they suggest, they suggest that it may be advisable for a court that is being asked to apply the judgment as res judicata to stay its own proceedings to await the ultimate disposition of the judgment in the trial court or on appeal. So I think here we can only go forward with part that, even if you find, or you either have to find that there's no just res judicata, no collateral estoppel, you actually have to find against Mr. Phillips on that for us to proceed here, rightly proceed and properly proceed without creating a real quagmire, a real tangle as far as what happens. Because what happens if the zoning permit is not overturned, but there's still a basis for it to be overturned for the reasons that I said, separate and apart, which now have been found to be res judicata. You now have 1 million square foot. You can't just pay money and make it better. You now have 1 million square foot facility that is generating thousands of trips of trucks, tractor trailers, package trucks, and vehicles every single day. That's creating all kinds of issues at traffic signals and traffic lights. And the problem is that, how does that get undone? So you have all that damage has been occurring all this time because they're allowed to proceed at their own risk, as we know, with their zoning permit and building permit and to commence construction. There's nothing about this proceeding that's stopping them from going forward and building it. And if they have that much faith to go forward, build it, and see how this all turns out in their favor, and all said and done, and they've been operating. So for those, let me just finish just one thing, and then I want to obviously respond to anything that anybody else has to say, other council has to say, is that it's our position that we had to file this appeal within 30 days, within the time period when it was issued. We had no choice. But at this point, we believe that for the reasons that I've stated, that it may actually, and it is actually premature to hear this case right now. In addition to the reasons that I've stated, we've put out right to know requests to the streets department. It's interesting that at this point, the only thing we have is one traffic impact study when we know that 3 were submitted to the city. We have one set of meeting minutes when we know there are multiple meeting minutes, and the meeting minutes that we have reference other documents that weren't provided. So in order for this board to properly adjudicate this, and then if you are to go forward, run the risk of what happens on an appeal with the zoning issue, is we don't have the documentation from the city, from the streets department. I don't believe we have any witnesses here. So we'd ask that the board actually not hear this case at the present time. We've preserved our rights by filing the appeal, that we allow the zoning issues to resolve themselves. So you're not placed in, and the city's not placed, and the parties aren't placed in this difficult position of moving forward here while there's still this appeal that could be overturned. That there's a subpoena that's issued for, typically the city does not allow and right to know requests. They don't issue the building permits and construction drawings. We've never seen those. We'd ask that there's a subpoena issued by this board for those things, and that the certain streets department representatives that were involved in this review, if there are no documents, somebody had to do something. We've got 2 documents and nobody else saying what they did from the streets department. They should be able to come in and tell us what did they review and consider, because right now we have somebody that's saying what they reviewed and considered and the basis for their approval, which then served as the basis for L&I to issue the building permit, was incorrect.
Okay.
Which is
Mr.
not a zoning
Ortiz,
issue. Yes.
I have a couple of questions for you.
Sure. Yes, sir.
Why not just go back to common pleas and get a stay, and request a stay of that?
Stay of what?
Get a stay in terms of this matter that you're raising now.
We're here in front of this board or in the courts?
Common pleas court.
We may actually do that. We're going to see what happens. We're waiting for Judge Coyle's decision. And we're also, and also, what's that? I'm sorry.
The other
And it
person
doesn't
said-
appear, it doesn't appear as if we've been watching the site, not like, sitting there all
Okay.
the time, but it doesn't appear that they're moving forward aggressively. It looks as if when I check on Eclipse, that there's only one initial inspection that's happened. So it doesn't appear, and Mr. Phillips can probably speak better to it. It's resources that my clients have. You understand, my client is a community group with only a couple hundred members. So we have to pick our fights where we
I
can.
understand. But the other question for you is that your appeal
sir.
wasn't, I don't believe, and correct me if I'm wrong, your appeal was fairly general. It didn't go to the specificity of the traffic issues and the permits that were issued for those matters. And that's
So-
I don't even think those permits have been issued yet, right? In terms of the roadway widening and traffic signaling and all kind of thing.
Well, there had to be preliminary review. There's no question by the streets department. The streets department had to sign off on
But that's
certain.
not my point. My point is that there had not been, to my knowledge, that's what I'm asking for you to speak to this, specific permits issued for road widening, traffic signals, etc.
We don't know if they have or haven't, and we could maybe appeal those. We're talking about the review that served as the basis for this particular building permit. That's all we have in front of us right now. In
Okay.
terms of the actual appeal itself, yes, there's, so many lines on the form and you can attach addendums. I think anybody who knows me, who knows what I submit to the boards, knows that I probably put as much information as anybody, if not more than anybody, in that. You put forth certain points, but I don't have to make my whole case on my appeal form.
Oh, no,
That's what we have the hearing for. And I think I reserved our rights. I think I stated quite a number of things that we feel that there are issues with. And you have to understand at the point in time when we were filing that, we were still waiting for responses on the right to know request. And we still are waiting for responses on the right to know request. So we weren't fully informed at that time from the city of Philadelphia as to what exactly had happened at the streets department. We still don't exactly know, but because we've only gotten 2 documents. But there's a reason why we can't wait more than 30 days and say, we're going to still file the appeal. I had to file it within that time period, and I provided all the information that I had available to me at that time.
Okay.
And that we had based upon our right to know request.
Now, keep in mind, this is a by right permit. So just keep that in mind as we consider these initial arguments before we make a decision. Mr.
Right,
Rogers?
we're challenging that. We're saying that it doesn't. We don't believe, aside from the zoning, there's a zoning issue, which if that fails, this building permit fails, which Mr. Reuter said, there's this other side where we feel that at least one of the department's prerequisite reviews and approvals was defective.
Okay, Mr. Rogers?
Sure. I just wanted to address a couple of things. Probably, trying not to prolong this more than it has to be, but in terms of, yes, Mr. Orphanides and his client can seek a stay, or really it would actually not be a stay. They would seek an injunction that wouldn't involve the city, and the city wouldn't take any position on, but an injunction against Roteva to preclude any construction activity from taking place until, whenever the end of until the zoning permit cases are resolved or something like that. So they always have that ability to go there. With respect, and it does seem like we're all in agreement, more or less, that the zoning issues really aren't and can't be before this board. Those will play themselves out in the court system. To the extent that that there are any non-zoning related challenges to the issuance of the building permit, we do spend it's the city's position that the notice of appeal was a little bit broad there. And again, we don't want to get into a situation which arguably we had at the zoning board, where we have an appeal in search of the reason for the appeal. If they believe the permit was improperly issued, that's based upon the face of the permit itself, and what and they're saying, like, the city shouldn't have issued this building permit, and these approvals by the streets department, and they're accurate. They have, and they had in the past, the zoning board at least, they had expert witness testimony prepared. They had reports prepared. It's my understanding. I mean, if they believe that the permit was improperly issued, I'm not sure why they need to subpoena streets department employees to give their opinion on why they issued the permit. That's not really a relevant question. I mean, again, that's a legal determination as to whether you have a permit that was issued that shouldn't have been. As far as the details of the permit, that's Mr. Orphanides is correct. The city does not typically issue building permits, or certainly not building permit applications and plans to the public, and that's primarily because of security concerns. We don't want bad actors seeing how buildings are constructed and finding ways to infiltrate them or break in or that kind of thing. We would give up those documents. We would produce those documents had there been a subpoena request, but it's the day of the hearing, and now, and earlier today was the first time Mr. Orphanides and I did speak. Today's the first day that the request is being made to subpoena documents. It seems like that could have been asked for quite a long time ago. Again, in the context of the zoning case, Mr. Orphanides and one of the partners in his law firm, Mr. Toner, they requested, they asked the zoning board to issue subpoenas several weeks, if not a couple months in advance of those hearings. I'm not sure why that wasn't done here. I'm also, and then ultimately, I think there's another problem. While I believe that the zoning board has no authority granted, this board, Board of L&I Review, under the administrative code, has no authority to grant a variance from a building code requirement. However, I do think the board probably has jurisdiction to hear an appeal of the building permit issuance. However, to the extent that the non-zoning related challenges to the building permit are going to involve, if they're allowed to go forward at all, that they are likely to involve highly technical matters, I'm not sure that this board, this appeal should have been brought to this board in the first place. I'm not asking for it to be continued. I'm just saying, because arguably that was something that should have been done within the 30 days. I'm not sure why the appeal was not taken to the Board of Building Standards. The administrative code clearly says any person aggrieved by the issuance of the permits governed by the technical codes has the right to can go to the technical board, which in this case would be the Board of Building Standards. I'm just, again, to the extent there's going to be factual questions and determinations about whether, again, non-zoning related, but very technical questions about, say, streets department prerequisite approvals, or maybe water or other sorts of things that get into the International Building Code. I think it becomes very problematic to have those particular issues heard by this board, and again, we would argue that it's too late to bring it to the other board at this point. But that being the case, the city, we would point out again that to the extent that they were just now asking the board to issue subpoenas for documents, we think again that's very problematic, and we would object to that. I think just looking at the clock and everything like that, we would ask the board to today just limit itself to this motion to quash and the issues raised there, because I think it's pretty obvious that one way or the other, it's not going to be practical to get into them. If we get into the merits of the case, it's not practical to do that today. It's already 10 till 3. There's 20 other cases on the list that are still live.
Thank you. I think the board has heard sufficient information from all council, unless I hear something different. And again, any members of the board review have any questions of the three council who are here before we come to a decision? If you don't, then I'm fine with that. I'll just give a moment. Did you any questions for Mr. Orphanides, Mr. Phillips, or Mr. Rod? If not,
no
question.
All
right, thank you.
Mr. Chairman,
Mr. Orphanides, I think we've heard everybody, so I'm not going to prolong this. We're at a point where we can make a decision.
Wanted to address the BBS question.
No, I don't want to do that. I don't want to do that. All right, thank you. Okay, having heard all from able counsel and making your positions heard, it appears that essentially this is this matter in one sense regarding the matters that fall within the zoning area are moot. That's been resolved. It's outside of the purview of this board to decide that. It's also fairly clear that the additional matters with regard to traffic, with regard to streets department permits, there may be other matters in terms of lighting, stormwater management, all those matters become technical matters that should be for the Board of Building Standards. It is not within our purview to make that decision. And so I'm certain that not everyone will agree with the position that we're taking, but I think that's where we are. And so we're not going to hear any further argument today. This matter is moot in terms of how to, particularly how it's based on the zoning matters. And we think that's the overriding issue here. So that's the position of the board. And you have, of course, you can submit a new appeal if you like, more specifically tailored to a different issue. But this is where we are today. Thank you. We appreciate your arguments and your presentation, but that's the decision of the board. Thank you very much.
Can I just ask for clarification, for purposes of the board's decision, is the board issuing a ruling on the motion to quash?
Oh, yes. The ruling, the request that you made, yes, is authorized. It's the fact that you requested is made. We agree with that.
Thank you.
All right, thank you. Thank you, everyone, for your time, your effort.
The board didn't vote.
Oh,
So I think
well,
it was-
generally, what we can vote for, given the nature of this, I'll ask for a vote, just so that we're clear. Normally, I would pronounce the board's position on a matter that we didn't hear. But I would ask the board members to whether or not they concur with the chair's stated position. And that is to grant the position, the motion to quash, as well as to state that the board's authority, it's not within the board's authority to hear zoning matters all over again. It's been resolved, so it's moved. Okay, I will call the vote.
I concur with the chairman.
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 Thank you very much. Okay, I
Thank
think we're
you.
resolved.
Thank
Thank
you.
you, everybody. Have a good day.
Thank you.
Let's move on to the next matter.
Yes, we have case number 3, appeal number HA-2021-001318, Esther Ekwale for 6729 Elmwood Avenue.
Yes, good afternoon, board. I will be representing my mother. She had to step out for another investigation interview for her job.
Okay, that's a problem. Is your name on the deed?
Oh, it's Esther O. Ekwale, daughter. I put like daughter/witness.
But what I'm saying to you is your name on the deed.
On the
Are you owning the property?
No.
Okay, do you have anything in writing from your mother to represent her interests?
An email was sent as one of the people that would be representing her.
She doesn't, the individual owner has to be the person or a lawyer. You don't, the other individuals are not granted that authority. Who's representing the city in this matter?
I thank you, Leonard F. Reuter for the city of Philadelphia. We have, well, I think a couple things would need to be clarified if the case went forward, which is that it's not really clear what's being appealed from. But I would state the property is currently under a cease operations. And again, that is, we believe, is not related to the actual violations that were appealed from here, or that could have been appealed from. You know, again, it involves fairly significant violations at the subject property. We would normally object to the case having to go forward. We think that the appellant had the opportunity to be here, and by not being here, they've essentially waived any argument. They've essentially waived their appeal.
Okay.
But
would you give me that address again, please, Mr. Rowder?
6729.
Hold on.
Yes, 6729.
I'm late.
Somebody's not sorry, 6729 Elmwood Avenue.
Okay.
There's violations that go back a couple years, back to 2020 when the property was first seized. I can make an offer of proof that if called to testify, the city witnesses, the city witness would testify that the property
Okay.
was initially ceased in 2020.
All right, thank you. But the first order of business, we may not even get that far because we need the owner of record to be present and be part of the argument. And she doesn't have the authority to appoint you to do that, particularly unless I get different advice from my legal counsel who's on it.
Okay, I'm sorry. Can I just state one thing?
Now, just one moment. I'm waiting for a reaction from my legal counsel.
Okay.
You're muted, Mr. Jefferson.
Well, you're advised to wait.
Okay. Will she be back before the?
Yeah, she can come back at 3:30.
Okay, we'll wait till she returns. But she has to be the person.
Okay, all right, no problem. Thank you.
Okay, Mr. Ryder, we'll have to impose on your schedule today.
If she's got, as long as the hearing, right, if the hearing's not heard today, and if she doesn't return today, then we would at that time ask if we feel to deny or dismiss the lack of appearance. Thank you.
Okay, all right, we will then move on and come back to it before we finish today. Thank you. What do we have next?
Next we have case number 9, appeal number HA-2021-001631 for Ju Anna Wu. I'm sorry if I messed the name up.
Could you spell that, please?
It's ANYANWU.
Ayamu, okay.
And the
It says
address is 7219 to 27 Woodland Avenue.
Okay, thank you. Who's representing the city?
Chairman Woodson, Mary Costello on behalf of the city for this matter.
Okay, and it's Jude Ayamu present. Jude Ayamu, 7219-27 Woodland Avenue. That individual has not.
No, I don't see them.
Okay, did we give service to this person?
Yes.
Okay, Ms. Costello, what is your preference here?
We would request a city affirm for lack of appearance.
Okay, all right, thank you. All righty. Mr. Petty, what time do you have?
2:58 p.m.
2:58 p.m.
Correct.
Okay, 2:58 p.m. We will then poll the board regarding HA-2021-001631, Jude Ayamu, 7219-27 Woodland Avenue, city affirm lack of appearance.
City affirm non-appearance.
City affirm lack of appearance.
City affirm non-appearance.
City affirm non-appearance.
Thank you very much. Okay, that matter is resolved.
And
Okay,
Chairman Woodson, I would just ask that Inspector Conway could leave the meeting because that is the only matter I had.
yeah, have a good afternoon, Inspector.
Thank you.
Okay,
Thank you all. Good day.
good day. And what's next?
Next, we have case number 16, appeal number HA-2021-001989, Danny Blount for 3422 Fairmount Avenue.
Okay. Who's representing
Amy,
this
good
one?
afternoon. Amy Skiles on behalf of the city of Philadelphia for this matter.
Good afternoon. Danny Blount. Danny Blount. Okay. Mr. Alfred, did we issue proper notice to Mr. Blount?
Yes.
Okay. Ms. Skiles, what is your preference?
Excuse me, Mr. Chair, just to
Yes, sir.
clear my records. I have mute comply.
For that was for the one above that for
Oh, okay.
126 South 8th Street.
Thank you.
Okay, you're welcome. Ms. Skiles?
We would be asking for a city affirm for lack of appearance today on that matter.
Okay. May I have the time, please?
3:00 p.m.
3:00 p.m. All righty, thank you very much. With regard, then we'll poll the board regarding HA-2021-001989, Danny Blount, and that's Blount at 3422 Fairmount Avenue, city affirm non-appearance.
City appearance.
City affirm lack of appearance.
City affirm non-appearance.
City affirm non-appearance.
Thank you very much. That resolves that matter. Okay,
Mr. Chairman, can we let, number 2, the appellant, Jai Boy Yang is still in? I don't know if he's aware that his, appeal has been withdrawn.
oh, okay, call him, put him on the record then.
Mr. Yang? Can you hear us?
Just state the outcome of the
Okay.
case.
This is number 2, Jai Boy Yang, appeal number HA-2021-001083, 761 East Allegheny Avenue. This appeal has been withdrawn.
Okay, thank you. Of course, Mr. Yang is welcome to stay with us, and this is a public forum. He's permitted and encouraged if he wants to listen to the end. Thank you very much. Let's go on to the next matter.
Okay, next matter is case number 20, appeal number HA-2022-001965. Appellant is Brian Monroe for 1501 North 8th Street, entire interior.
Good afternoon, members of the board. Jeffrey Cohen for the city.
Good afternoon, Mr. Cohen. Who's representing Brian Monroe?
I believe I see Mr. Monroe, but he's muted.
I've just asked him to unmute.
Hello, board. I'm here, Brian Monroe.
Mr. Monroe, this property that we're working on, is this something that you own as an individual?
No, sir.
Who owns the property?
The guy I was doing the work for was a general contractor, and
what is your position here? What is your role in this?
I'm an electrical contractor.
And so why are you filing this appeal?
Members of the board.
They sent me a mail. I never even got a notice of any problems, but they sent me some mail.
Hold on for a moment.
Saying I had a. Okay.
Hold on for a moment. Mr. Cohen.
If I may make an offer of proof.
Yes.
This property in question, 1501 North 8th Street, is owned by New Sphinx Realty. That property had undergone unpermitted repairs and interior renovations and conversion without any permits a while back, several years ago. And at the point that this notice of violation was issued in, I believe, January of 2020, the owner of that property had hired several contractors, including Mr. Monroe, to try to address these permitting issues. But then only one of the permits had been actually issued, Mr. Monroe's permit, and that permit has never received a final inspection. So we're here today specifically with respect to Mr. Monroe about that electrical permit and with the property as a whole, because none of the work has been properly permitted.
So, but the owner did not appeal anything.
The owner did not.
And the only person who submitted an appeal was the electrician.
That's correct.
Okay, and so let me, just so I understand for the record, if we carve this electrical matter out from the rest of the building, what does the city then do with the rest of the issue? Because we can't make a decision on the whole case.
Of course, what the city is defending today is that there was an electrical permit pulled for this property, but it was never finalized. An inspection never took place. The permit was pulled several years ago, I believe, issued on July 3rd of 2019. And at this point, it's very stale, members of the board. And I do have Inspector Salim Mohammed here today to testify on behalf of LNI about the current status of the property and specifically the electrical permit.
Okay, so the issue then is carving out the electrical permit as a individual matter. Now, is your inspector an electrical inspector?
He is a construction inspector.
Don't you need an electrical inspector to opine on Mr. Monroe's permit and electrical work?
If we were delving into the specifics of the electrical work, you would be correct. But since we are talking about the paperwork and the facts that are recorded in LNI's CLIP system, a construction inspector is more than capable.
Okay. Mr. Monroe, are you the sole owner of your electrical company and the permit applicant?
Yes, I am.
You applied for the electrical permit, correct?
Yes, I did.
Okay, thank you. All right, then we can go forward then. Okay. Before we move forward, Mr. Monroe, I need to swear you in. You raise your right hand so that you can be sworn. Do you swear or affirm the testimony that you give today be the truth so help you God?
Yes, I do.
Okay, thank you. Do you have an inspector, Mr. Cohen, that should be sworn?
Yes, Inspector Salim Mohammed, who I believe needs to turn on his camera and unmute. There we go.
Good morning or afternoon.
Okay, Mr. Mohammed, would you raise your right hand so that you may be sworn? Do you swear or affirm the testimony that you give today be the truth so help you God?
Yes, I do.
Okay, thank you. All right.
Thank you.
Mr. Cohen, please proceed.
Thank you, members of the board. And thank you, Inspector. If you could just briefly tell the board how long you've been an inspector with L&I and in what capacity?
For the last 7 years.
And in what capacity?
As a building inspector and now as a court administrator for the building division of license and inspections.
And has your duties brought you to the property at 1501 North 8th Street?
Yes.
And have you reviewed L&I's records for 1501 North 8th Street?
Yes.
Let's start by taking a look at the property. If I could please share my screen. I have an exhibits packet.
Okay, please.
Here we go. Can everyone see this packet?
Yes.
Inspector, if I turn to page 2 of the packet and show the photograph depicted in what's labeled as Exhibit C1, did you take this photograph?
Yes, I did.
When did you go? Well, is this the property at 1501 North 8th Street?
It is.
And when did you go to this property?
I believe that was last week. I believe that was Friday. The date is actually on the picture. It should be below.
I apologize.
Yeah, Friday. Yeah, that was this Friday past, July 22nd.
And can you please explain to the board what L&I has recorded in its system as the violations at this property?
Well, there are several violations that were written and for construction without permits. There was an electrical violation that was written. There were violations written that required an engineer's report. So there were several violations written for this property.
And I'm going to scroll very briefly to page 7 in the packet. Is this the notice of violation that you were just speaking about?
This is one of them, yes.
Oh, sorry, that's correct. Were notices issued to the property owner and the contractors attached to this project?
Yes.
And is this specific notice the one that was sent to Mr. Monroe, the appellant?
It is.
I'm going to scroll now to this page, page 8 in the packet. What specifically is the electrical related violation at this property?
This violation, or part of the violation, is written for wiring throughout and also a fire alarm system.
And going back up to the photographs here, is this photograph on page 3 in the packet, does this depict any of the new electrical service to the property?
Yes, it does.
And are there any finalized permits for this service?
No, there isn't.
I'm going to scroll down to page 37 in the packet. What is this that I've got on screen?
This is an electrical, information concerning the electrical permit that was applied for and issued.
When was this issued?
The date is July 3rd, 2019.
And scrolling down, well, actually, let's look at the approved scope of work first. What is the approved scope of work under this permit?
Right, it's for the repair or the installation of three 100 amp electrical panels in each apartment.
So this permit doesn't necessarily cover the installation of new service.
No, not necessarily.
And just scrolling down to page 39 in the packet, what's depicted on this page?
Well, it's part of the electrical, electrical permit, and it tells, gives results. There's an issue date and a completed date, and it gives an expiration date.
And are there any inspections under this permit?
Not under this one.
So could this permit be marked expired for failure to hold any inspections?
Yes, it is slated for expiration, yes.
And just briefly, unless there's an objection from Mr. Monroe, I would offer that we can stipulate that what's labeled Exhibit C5, starting on page 41, these are his electrical contractor's license, starting in 2019 and going through to the current active license.
That's correct.
And Inspector, is there anything else you'd like to add about the electrical violation or electrical permit violation at the property?
Well, electrical violations are taken very seriously, especially work done without a permit. And at this point, there have been no inspections, and even though the property is vacant, we have no idea of whether the work is to code, because there were never any calls for inspections. So it always poses a concern on the part of the department that these issues be taken very seriously.
Thank you very much, Inspector. I have no further questions this time, but I would reserve a bit for redirect if Mr. Monroe has some questions.
Mr. Monroe, do you have any questions of Mr. Muhammad based on his testimony?
No questions. I don't have.
Okay, then we'll just, if you don't have any questions.
Not on his testimony.
Okay, then we'll get to you in just a moment, okay?
Okay.
All right. Anyone else have any questions of Mr. Muhammad before we move on?
No question, Mr. Chair.
Okay. All right, thank you. Mr. Monroe, can you tell us then why you didn't get a final inspection and close out this permit?
Well, what happened was I was hired by a general contractor on a job, and the general contractor gave me a deposit. We went in there, started stuff, and we found out there was a lot more stuff involved in the job, because what was listed on the city website wasn't originally about any service. And I went and inspected the job, and I told the guy, well, we'll correct your violations, but you need drawings to get a service. I never installed a service there. Only thing we did there was straighten some outlets out, some switches and some hanging lights, and covered some boxes up. I never even got inspection on a property, because I found out that the city took the property for drug foreclosure, and the owner didn't own the property properly. And the general contractor walked out, and the owner said he was trying to get me to do the work. Last I heard, he was trying to get me to do the work, but he couldn't get money because he couldn't buy the property properly. And then next thing I know, I get something in the mail saying that I got a violation, and I get a call from this guy, Robert Parisi, saying that you did a job that you didn't get a permit for. And I tried to tell him, wait a minute, I got a permit, and if the permit wasn't right, all my life I've been licensed since 1993. L&I would give me a letter, and they would cancel the permit, say you didn't get enough work on your permit, so we're going to cancel the permit. This is a violation. You don't have enough work to cover. You don't have enough work on your permit to cover this job. So they cancel, But I never, from what the inspector's point of view, he's right about it and everything. But I never thought that it would be a problem to come back to me to violate me on this job that I never was really got into, and I had no control of.
Mr. Monroe, you realize as a licensed electrician, anytime you submit a permit application, it's all on you to close it out, not the general contractor, not the property owner, or you, the licensed electrician, correct?
I understand that. But if I can't get back in the property.
Okay, is that that's what I'm asking now, is what is your defense? Is that you can't get back into it to schedule an inspection? What's going on?
That was the problem. No one knew where I didn't know where the general contractor was anymore. I never got to meet the owner. I never could get paid. I'm sorry.
Did you get paid?
No, I never got paid. The job never got completed. Okay. And when I talked to Robert Parisi, I said, well, that I can cancel that permit. He said, well, you still got to go to court. And I didn't even know why I was headed to court, because I've been in problems like this before. I never had to go to court. I always was able to work it out with the inspector, whatever the problem was.
Okay.
And I see no reason why I'm in court if the job is violated and it's on the building already. If the permit is no good, that job stays in violation. They can't nobody
Well,
move in the place.
You're here because your name was on a permit application.
That's
and
correct.
It wasn't closed out. So that's why you always go to the person's name on the application.
I understand that. I
And that's why
understand.
you're here.
I understand.
Any
that.
other questions for Mr. Monroe?
Yes, members of the board, just one. Mr. Monroe, you had said that essentially you didn't get paid for this job, that this job was a larger one than you thought that it would be, but you didn't follow up formally with L&I and request that the permit be canceled or abandoned or dissolved, correct?
No, I wanted to get back into the property to see what's going on with the property. From what I heard, what Robert Parisi said, that someone else was working on a property, and it's fallen on me. So by the time I contacted the owner and finally got in touch with the owner, I was already in court about this. And I finally contacted the general contractor, found out the owner, and I found out he couldn't buy it. So I don't know if this is all because this was a drug property or whatever happened. The city didn't want the property open or whatever, and I stepped in. I don't know what happened. You're right. I should have closed out the permit, but by the time I got a notice, I was already in court. I never got anything from the city. I usually get a letter, stating, hey, you have a problem. It's not enough work. I'm a licensed electrical contractor. They can tell me if there's a problem. You can call me and tell me if there's a problem with a job I have, or email me and I'll respond. I shouldn't just be holding court.
Mr. Monroe, let this be a
Yes.
lesson. It's always on you. So you have to take the aggressive action to close these jobs out.
I understand that.
So don't expect someone else to let you know. You take the action because you're the one sitting here now.
I understand that.
Anyone else have any questions for Mr. Monroe?
I have a question, Mr. Chairman. So Mr. Monroe, you were saying that you typically get some type of correspondence from the city. Did you not receive the notice of violation in January of 2020?
No, I did not. No, I did not.
You did not receive that notice of violation?
A notice I got, if it was a notice, it was a notice for a hearing.
And is your correct address 1646 Felton Street?
No, it's not.
Okay.
My
If I
address
could
is
point
20
out for the record, we're here because the notice of violation sent to Mr. Monroe was appealed. It was appealed 9 days after the January 2020 notice was issued and sent.
That was a notice of a violation, right?
Yes, that was
Of a
Exhibit
court
C2.
hearing. That was a note of the court hearing.
No, are you talking about the notice of, okay. I apologize. I may have missed your exhibit, Mr. Cohen, but I'm asking you if you're saying that he did file an appeal of the January 2020 notice of violation. Is that what's on appeal now?
If I could share my screen, maybe we could have Mr. Monroe identify what the January 2020 notice was.
Okay.
Give me one moment. This is on page 7 of the city's packet.
Right. This is what I'm asking Mr. Monroe if he received.
Let me read this.
Do you remember receiving that notice of violation, Mr. Monroe, with the electrical permit being addressed on the second page of the notice, 4
On January-
paragraphs down?
I don't remember this. No, I remember a court hearing.
Actually, members of the board, I may be able to answer this as well if you'll indulge me.
Sure.
On page 31 of the packet, I've included the appeal form that was submitted. This was submitted January 29th of 2020, and attached to the appeal form is the initial notice of violation.
Okay.
Yeah, that's it. That's the one.
All right. That being said, Mr. Monroe, why did you not address the violation with the city at the time that the notice was sent to you?
I tried to address it with the inspector who contacted me, Robert Parisi.
And when were you contacted by Mr. Parisi?
This had to be a couple of days after this notice here.
So between January of 2020 and today, you've made no additional attempts to contact the city and the Department of License and Inspection to address this issue of your permit?
That permit, because I looked in the city and this permit was canceled.
When was it canceled? When
The
were you
last time I
made-
looked in the city, it was not in the Eclipse system. I looked in Eclipse and it wasn't in it. I looked it up in Eclipse and it wasn't in it.
But my question is, when did you do that?
The last time I looked at the Eclipse system,
Yes.
a few weeks ago, before here I looked, it wasn't there, and
But you're making my point. My point is that, but between the time that the initial notice was received and you filed the appeal, and
Mhm.
now we're in 2022, more than 2 years from the date of this notice.
well, it was
you're-
COVID. It was COVID going on. A lot was going on with COVID. When that happened, we went right into COVID, and I was
No, I
trying. I
understand.
even called up for find out if I had to go to court and all this, and they said, "Oh, those people aren't there," and it was we went into a COVID thing, and a lot of things. I wasn't even going out the house to do
I
anything.
appreciate that, Mr. Monroe. Neither
Uh-huh.
were any of us. But my point still, and my question to you is,
Mhm.
you've made only one contact with the Department of Licenses and Inspections, through
Mhm.
Mr. Parisi, since January of 2020 to address your electrical permit. Is that your testimony today?
I'm sorry. I've made I may have made contact with the city maybe more than once. I've talked to several people about this about people down there when I finally was able to get down there for an appointment, and that was face to face with people when I did talk to people down at license inspections. But I thought that, this is my first time ever going through a hearing with the city and all that stuff there. I just thought that, I go to the hearing and that would be the end of it. Far as when I talked to the owner of the property, he said he couldn't do anything with the property, and he said he would like to get me to finish the job, but he was in court trying to get the property back, because I was dealing directly with the owner about maybe a month and a half ago, and he said he was still trying to get the property, and at that time, and I wasn't dealing with it. He threw the general contractor out and stuff like that. So I know I just made the small attempts that I didn't make to do that. I know now what the city is looking for far as closing things out on time and stuff like that. But I didn't know at that time. And I've always, did jobs and, closed them out on time. I never got into a situation like this where you have so many problems with a drug property and a guy who can't pay, and a general contractor doing something and bringing his own guys and everything else. Before
Mr. Monroe, let's keep it narrow, because this is all about the process of you as the electrician canceling or closing out of permits you can't complete. Have you ever had to do that before on a job?
Cancel a permit that I couldn't complete?
Yeah, a job that you got into, you had the permit for, but for whatever
Yes.
reason beyond your control.
We always call the underwriter. We always call out.
So the answer is yes, correct?
Yes,
The answer is
yes. I called the underwriter.
Why didn't you do that in this case? So why don't you do that now?
I can do that. I can do that. I thought it was closed out.
Now, how do you? It can't be unless you take certain action. You're the permit holder.
Why? Reason why I thought I talked to the inspector. I put in.
No, sir. You have to do it as the permit holder. I don't care who you talk to. You have to
Understand.
take certain action.
I understand.
You're
Well,
a licensed electrician.
You're right. You're 100% right. And I just want to add to it that, from the time that we started doing this, that's who always closed our permits out, our underwriters. We call them.
But your underwriter did not come to this job. You have to call the underwriter.
No, understand. Even if they don't come to the job, we still would call them and say, hey, we didn't touch this job. It's a problem. We need you to close it out. And they would close it out for us.
Did you close it? Did you
that's
call the
how
underwriter?
it was.
Did you call the underwriter? Did you call the underwriter? You did call the underwriter. And who was that underwriter?
At that time, I think I called Sundog Energy at that time, and I called I think it was Sundog Energy.
You have anything from them that you did that? Did they take any action?
What do you mean? Paperwork from them?
Yeah.
No, I wouldn't have paperwork from them. I don't usually get anything from them. I just,
Okay. All right, thank you. Any other questions, Mr. Monroe?
Now, Mr. Chair, just a statement to Mr. Monroe. There is a time frame on every permit. And from 2020 up until now, I believe you have reached that time frame where the permit pretty much expires. And it's your responsibility as a licensed electrical contractor to keep track of that. No matter what happens in any situation, COVID or change of ownership, you have to be aware of that. And if you said you used Eclipse, then you definitely should have known and got an email letting you know that this permit was about to expire and you needed to take some action. So you want to be aware.
You're right, Sumi. Let me just say this. This
Mr. Monroe, that's okay.
Okay.
Because we had to move on. I don't want to continue.
Okay.
Necessarily. And I guess I'll go back to the counsel for the city. Given that this is not a technical issue regarding his license, what's the most appropriate way to resolve this?
Actually, I was about to offer, if the appellant is inclined, the city would agree to a city affirmed with a stay of enforcement for 30 days so that he can complete the cancellation of this permit with the city. And I would also like to add for the record, it's Exhibit C6 in the city's packet on page 45. This is the deed, as you can see, the stamp of recording with the City Department of Records in 2013. That the Office of the District Attorney had already seized this property and had sold the property to New Sphinx Realty. So I believe that was the drug matter that the appellant had been alluding to.
Okay.
And with that, the city would move into evidence the exhibits C1 through C6 in its packet.
Okay, so noted. And so with regard then to this particular matter, we will then call the vote on HA-2022-001965, Brian Monroe. The address is 1501 North 8th Street. City affirm a 30-day stay of enforcement.
City affirm a 30-day stay of enforcement.
City affirmed 30 days stay of enforcement.
City affirmed 30 days stay of enforcement.
City affirmed 30-day stay of enforcement.
Thank you very much. Mr. Monroe, also these matters, although we are not common pleas court, we also expect everyone to show up and take the matter seriously. So that would include the way you present your information and yourself, okay?
Okay.
Okay, this is a formal hearing. So
Hey.
please come appropriately dressed in the future. Thank you.
I know that, sir. Thank you.
Okay, what's next?
Next we have case 21, I'm sorry. Case number 21 and 22 is the same appellant in the same address, but they're two
Okay.
different appeals numbers. So I'll read them together.
Okay,
Okay, this is case number 21, appeal number HA-2022-001970. Alberto Kua Ming for 5246 Belfield Avenue, AKA 5246 to 50 Belfield Avenue. In case number 22, appeal number HA-2022-002696, appellant Alberto Kua Ming, 5246 Belfield Avenue. And he's represented by Christopher Kaufman.
all right, thank you. Who's representing the city?
Good afternoon, Amy Skiles on behalf of the City of Philadelphia.
Giles, good afternoon, and Mr. Kaufman, you present.
Good afternoon, Mr. Chairman. Christopher Coffin on behalf of the appellant.
Okay, thank you very much. Ms. Giles, it's fun that you didn't kick us off.
Yes, and I will be calling Inspector Anthony Williams to present testimony.
Okay, Mr. Williams present. Mr. Williams, unmute yourself so I can swear you in. You raise your right hand, sir. Do you swear or affirm the testimony that you give today be the truth to help you God?
Yes.
Okay, thank you. You can place your hand down. Ms. Giles?
Okay, Inspector Williams, can you state your where you're currently employed?
I'm code enforcement inspector for license and inspection.
Okay, and how long have you been performing that role?
3 years.
3 years. And are you familiar with the property at 5246 Belfield Avenue?
Yes.
And how are you familiar with that property?
Well, I was asked to do a re-inspection last Thursday. It's not my original case, but I did do a re-inspection just to verify that the things that were written in the case were still evident.
Okay, so you have visited the property?
Yes, that is correct.
Okay, and with the permission of the board, I would like to share my screen.
Yes, please.
Okay, Inspector Williams, can you see what is identified as City Exhibit 1?
Yes,
Okay, and what is City Exhibit 1?
that's the initial notice of violation.
Okay. And just to be clear, this is the notice of violation for case number 720132.
Yes.
And when was this notice of violation issued?
It appears that notice of violation was issued 12/26/2019.
Okay. And some of the violations contained in this notice of violation have been complied, but I've highlighted the ones that are still uncomplied. So would you read the first highlighted violation?
Says individual containers, cartons, or packages shall be conspicuously marked or labeled, and I can't see that other part. Hold on one second. One second, I'm have to move the screen down. And an improvement in the rooms or cabinets containing compressed gases shall be conspicuously labeled.
Okay, and then this next highlighted violation?
Fire extinguishers must be inspected and tagged.
And then the next highlighted violation?
You must obtain the license indicated below for the activity conducted at this location or discontinue the activity.
And what is the license that was necessary?
For auto repair license.
Okay, and then finally, this last highlighted violation here.
It says you must obtain the license indicated below for the activity conducted at this location or discontinue the activity, and that's for the dumpster license.
Dumpster license, okay. So then I'm moving on to the second violation notice that was appealed. Can you see City Exhibit 2?
Yes.
And so this is for LNI case number 720134.
Yes.
And when was this notice of violation issued?
Also, it believes apparently on the 12/26/2019.
Okay, so I'm scrolling down to there was only one violation cited in this notice of violation. Could you tell me what violation was cited in this NOV?
Well, the violation was for them to get a permit for the vehicle painting on premises.
Okay, so they did not have the appropriate use registration permit.
At that time, no.
Okay, do they currently have a use registration permit for painting vehicles?
No.
What about the necessary licenses for the dumpster and the auto repair shop? Have they obtained those licenses?
No.
Okay. And so you made a visit to the property last Thursday?
Yes, that is correct.
And so before
last Friday.
Friday, okay. So that was July 22nd, 2022?
Yes.
And before we get into the photographs, what did you observe at the property?
Well, the case, everything that was written was still evident. They're still repairing cars. There's one side is storage for a furniture store, and the other side is auto repair, and they are actively painting automobile parts. Or, they said they were cars, but they're actively painting in the premises.
Okay. And so they're actively painting. And did you also see them actively doing auto repair work?
Yes.
Okay. And what type of work did you see them performing?
Well, a gentleman was working on one of the cars in the back, and he was, I couldn't tell what he was doing, but he was taking one of the parts off of one of the cars, and then along the right side where this picture is, there were a bunch of people, just kind of painting the various parts of the cars.
Okay. Okay. So now we'll go through the series of photographs that I've marked City Exhibit 3. Can you see this photograph?
Yes.
Okay. And so what is this how the property looked? Sorry, when you visited the property?
Yes, pretty much the same way.
Okay. And so what do you see here?
They have various paint cans and paint things to paint with that they were using on the cars.
Okay. And then this picture,
Yes, that was along the, I would say almost the front, like right almost towards the exit. And that was where they were storing some of the paints. Now they did, from the picture when Inspector Lee was there on 14 to when I was there, they did move some of that stuff, but most of the stuff was still there.
okay. And this is just another cabinet with more paint storage.
Yes.
And this, could you tell me what we're looking at here?
Well, it appears to be some of the paint that spilled on the floor. That was not there when I was there, but I didn't see that at the time of my inspection.
Okay. And then this picture, it depicts the dumpster still out front of the property.
Yes.
And as you said, they still have not obtained that dumpster license?
No.
Ms. Gauss, before you move from that,
Yes.
would you mind focusing on the bit, because I can't see the dumpster.
Sure. It is, if you see right there
Okay.
where my cursor is.
I see it, yeah.
Okay. And then Inspector Williams, what is depicted in this photo?
You have a couple of, you have a few unsecured containers. You have various auto parts, and they still look like some cars are in a state of repair.
And then once again, this is just another cabinet entirely filled with painting products.
Yes.
Ms. Stiles, can we go back one frame, please?
Sure. To this photograph?
Yes, thank you. Inspector Williams, could you tell me what that container is there, sir? For the
Which
record.
one?
The
There seem to be three of them.
The tall green one.
That's for the I believe for the welding. I'm drawing a blank on the actual name for it, but
It's okay, it's for welding. And is that a cart that it's on, if I'm correct, right?
yes.
Wheels?
So that one actually, I don't know. I'll let you finish. I'm sorry.
And this one is on wheels?
Yes.
Correct?
Yes.
And if correct me if I'm wrong, these two are propane over here?
Yes.
Okay, thank you.
Mm-hmm.
And then once again, this photograph, Inspector Williams, just more evidence of paint cans and paint supplies.
Yes.
And then this cabinet, do you know what is inside this cabinet?
It appears to be more of the spray paint supplies. Looks like a couple of things for the oil. Now that was not open when I was there, but they had various other closets with pretty much the same thing in it.
Okay. And we've seen this picture. And then once what is depicted in this picture?
It looks like more auto repair supplies and extension cords.
And then here, we're just looking at another view of
Yes.
more auto repair supplies.
Yes.
Okay. And then this picture, it looks like a freshly painted car.
Yes.
And then here, Inspector, you can see where it looks like someone's taped the cars to perform the painting.
Yes, and that's kind of near the front. So that's kind of more like the view of what's going on in that painting area that they were using.
Okay. Okay, so at the time that you visited the property on July 22nd, all of the violations still remain.
Yes, that is correct.
Okay. Then I would just move to submit city exhibits 1 through 3 into the record, and then I have no further questions at this time for Inspector Williams, I'm sorry.
Yep, the exhibits accepted. Okay, Mr. Kaufman, do you have any cross?
Just a few. Inspector Williams, who did you speak? Who was there? Who was present when you were at the inspection on Friday?
It was a Mr. The operator of the auto shop, Mr. I forget what his name is. 1 second, I have it. listed right here. I have it in my files. Just give me a second. Sorry, I'm trying to pull up the file.
All right, thank you. That's all right, Mr. Williams, can you tell me?
Okay, I have it. It's Mr. Scott Furman. Mr. Furman, allow me to get in. That was the operator of the auto shop.
Was the
That's how
owner
he
of
id-
the,
That's how he identified himself, as the operator of the auto shop.
thank you. Do you know, when you were there, was the owner of the building there at all, to your knowledge?
Subject to relevance of that question.
I'll withdraw it.
Okay, thank you.
I have really nothing further for Inspector Williams.
Okay, thank you. Ms. Giles, do you have any additional witnesses?
No additional witnesses. I would rest.
Okay, thank you. Mr. Kaufman?
Yes, obviously I've been working with the owner. The owner's been trying to work with the tenant. These are tenants that are there. We understand it's his responsibility. He's been urging them to get these items resolved. I was giving inaccurate information. I was told this morning that at the reinspection on Friday, there was 3 minor items that needed to be fixed. You know, the paint needed to be in the cabinet, identified the correct way as laid out in the violations, and there were some electrical cords on the floor. Obviously, you know, that's not the case here, but that's what we were told this morning by the tenant who was present at the inspection on Friday. I would ask that the board provide us some time to cure these violations and allow the owner, you know, myself again, to assist to try to get this tenant to comply with these requests.
Mr. Kaufman, do you have the owner present today?
Yes,
Yes, he's here.
I'm here.
All right, do you plan to call him as a witness? Because I have several questions for him.
Yes, we'll call him as a witness, yes.
What is his name? And I need to see his image.
It's Alberto Chua. Alberto, can you turn your camera on?
Yeah. Okay. Hi.
Mr. Chua, raise your right hand, please.
Can you see me now?
Yeah, I need to
Okay,
swear you
very
in.
good.
Mr. Chu, I need to swear you in. So raise your right hand so I can swear you in.
Okay.
Do you swear or affirm the testimony that you give today be the truth and help you God?
Yes, sir.
Okay, thank you.
Thank you.
Mr. Chua, how long has this tenant been renting from you?
Beg your pardon?
How long have this tenant been in your building? This tenant, how long has he been in your building?
About 3 years.
3 years, okay. Do you have a lease with him?
Yes.
Does the lease require him to organize the shop so he meets all necessary codes?
Yes, sir.
It does.
Yes.
Okay. All right. Thank you. Any other questions of Mr. Chua from anyone?
I just have a couple.
Okay.
Mr. Chua, have you told the tenants that they need to comply with these violations and fix these?
Of course. Okay.
And isn't it true that, you know, you spoke to the tenant this morning and he told you there was only a few minor violations?
Yes.
I have nothing further.
Okay.
I have a question, Mr. Chair,
yes.
from Mr. Chu. Mr. Chu, do you have a lease with the current tenant?
Yes.
How long is that lease for, may I ask?
That lease was written about 2 years ago.
And it was for 2 years?
After 2 years, we can extend it.
So when does it expire?
Usually after 1 year, we never extended the lease. It's going to be month by month.
So are you in a yearly lease or a month-by-month lease currently right now?
To tell you honestly, I never pay attention on this thing.
So you're not sure whether,
So whatever it's like an oral lease.
but let me back up.
Probably-
Do you have a
probably-
lease with the tenant? You have a lease with the tenant?
Yes,
Okay, you're not sure if it is month to month or year to year?
it's a long term.
Okay, you don't have a number for that long term?
Yes, because on the list, on the list, we wrote, this year he have to pay how much, next year up to 5 years.
So
The
you have
lease
a 5-year
is-
lease?
Yes, so it should mean that it's a 5-year lease.
Thank you.
Okay, Mr. Chu, have you taken any action against the tenant for his violations?
Only can tell him if he keep violation to the Philadelphia LNI, they're going to come to shut it down. That's it.
Okay,
Period.
all right, thank you. Any other questions of Mr. Chu before we call the vote on this matter?
No, thank you.
Okay, any final argument?
No, I would just say these notices of violation were sent in 2019. There's been plenty of time to comply the case. And in the appeal paperwork, Mr. Ming was stating that his tenant was not painting and they weren't working on cars, so they didn't need the licenses or the use permits, which is clearly not true. So we're just asking for a city affirm today.
Okay, thank you. All right.
Can I just respond really quickly to that?
Please. Yes.
Yes, at the time the appeal was filed, counsel is correct. That was what we were told. That was our understanding, that there was no painting of cars or anything to that effect. So that's why it was certainly written in the appeal. It wasn't written in there to lie or anything like that. At the time, that was the information that we had to go off of for the appeal. So it's not as if we're coming into this forum and not being candid to this board concerning that matter.
Okay, thank you.
Mr. Chairman, I apologize for a last minute interruption. May I ask Mr. Chua a
Sure.
question?
Mhm.
Mr. Chua, in the time that you entered into this lease agreement, have you ever personally inspected this property? Have you
No.
gone to the property? So you have never gone to the property to talk to the tenant?
I did go to the property, but at that time, the property is empty. You don't see any violation.
In
Later
20
on, when the tenant moved in, I didn't go in to check whether they follow the city ordinance or not.
So
Because
it's your testimony that after you received the notices of violation, you did not go into the property to see if the tenant was in violation of the city code?
I thought that is not my issue. I'm sorry, okay? I thought that is not my issue. I rent the property to somebody. I thought that somebody was taking care of it. Maybe that is my mistake, I admit, because I don't know.
But the violation was addressed to you, was it not?
Yes, but I did get when they addressed to me, I did get a lawyer to taking care of what they should do.
So you simply took the word of the tenant and did no physical inspections of the property yourself?
You are right, but I thought that that is not my issue.
Okay, thank you very much.
All right, thank you.
You're welcome.
Okay, we will then poll the board regarding HA-2022-001970, and we'll rule on both cases combined. And the second case is appeal number HA-2022-002696. The appellant is Alberto Chua Ming, that's C-U-A-M-I-N-G, property address 5246 Belfield Avenue, City of Fairmount.
City affirmed.
City affirm.
City affirm.
City affirm.
Thank you very much. That's the city's, that's the vote, the city affirmed. Thank you very much, everyone.
Thank
for your
you.
patience. Okay, have a
Thank
good
you.
afternoon. Okay.
Thank you, council.
Thank you.
All right. Before we go to the next case, Ms. Alfred, we've had a couple notices from someone who wasn't around when we ruled on their case.
And who is that?
That's Mr.
Maya Yang.
Yang. Yeah, Mr. Yang.
Yes, I've been chatting with him. He was going to call me once the meeting was over. His concern is he's concerned about a vacant license fee.
Oh, okay.
And
Right.
I knew that was something that you could not help him with. So I said that I gave him a message for him to call me, and he said okay.
Oh, good. Okay, thank you. Thank you.
Excuse me, Mr. Chair.
Yes, sir.
We also have Esther.
She's
Case
being
number
called. She's
3.
being called next.
Okay, thank you.
Okay. All right, why don't we call her now then?
Yes. This is case number 3, appeal number HA-2021-001318, Esther Ekwale.
Okay. Okay, Mr. Reuter, we're back again. Do you know if the appellant is present or not?
She said she was in. I don't know if she's waiting in the waiting room on Zoom.
No, there's no one in the waiting room.
There's a unidentified phone number.
Yeah, this is an unidentified cell number. It's been in here for a while.
And if I can interrupt really quickly, Mr. Reuter, if you could talk louder for me, please.
Okay, I'll try to. I've been having sound issues with mic issues with Zoom for some reason.
Yeah, I'm going to buy you a new headset. How does that sound?
It works with everything else. Just for some reason on Zoom, it's a problem. But I'll speak up.
Okay, we have Miss Ekwale she just entered the waiting room.
Okay.
So,
hi, Miss Ekwale, can you hear us?
Hello?
Hello, can you hear us?
Yeah, I can hear you.
Okay, great.
Mrs. Esther Ekwale?
Yes, Ms. Ekwale, I'm Kenneth Woodson, the board chair. And I need to swear you in, so if you raise your right hand so that you may be sworn. Okay, this isn't working.
But she's frozen.
Yeah. Miss Ekwale, did you hear me?
Yeah, I can hear you.
So would you raise your right hand so that you can be sworn?
Yeah.
Okay, do you swear or affirm the testimony that you give today be the truth to help you God?
Yeah.
Okay, now one of the requests that I have of you is that I need you not to keep walking. You need to stand still because it creates problems for us being able to speak with you and to hear you, okay? She's frozen again.
Okay.
Can you hear us?
I need to listen.
Okay, we need you to move to a different spot because apparently wherever you're standing now, you aren't getting good reception. Can you move around to a different spot or you went away? Oh, there she is. Ms. Ekwale, can you hear us now?
Yeah, I can hear you now.
Okay, thank you. Now we do have Mr. Rodder, we do have a problem here with the appeal dates.
Yes.
There's an
So-
issue of whether or not this is even a matter we can hear today. Yes, sir. Would you
Thank
start
you.
with that?
That's right, sure. That's what I was going to address first. And please, Ms. Ralph, if you need me to speak up, let me know. So the appeal that is before the board today was filed March 2nd, 2021. And it is date of violation refusal notice is February 6th, 2021. And this is all on the notice of appeal that was submitted to the board. But it lists violations of the property maintenance code, administrative code violations, fire code violations, etc. And those violations were actually issued back in July of 2020. And what was issued in February of 2021 was violations, plumbing violations and property maintenance violations that involved sewage in the basement because of apparently clogged or not working plumbing stacks and sewer lines. So it's the city's position that the only appeal before the board would be appeals from those sewage in the basement matters and not the other violations that are listed on her appeal. I would note, though, for the record, and I can have, I should also note Martin Raudenbush is here for the city, and he can verify what I'm saying. But again, I'm making offer of proof that we did. So the July 2020 violations, I think it was July 21st, 2020. That was issued July 21st, 2020. And then a final violation notice on those violations was issued February 6, 2021, but that final notice itself is not an appealable document. In fact, it specifically says that the whole point of that document is to tell you that your time's up, that you have passed now the time to take an appeal, and that you are you must be in compliance and that fines are starting to accrue. So if you want, I can have Mr. Raudenbush go over some of these documents, but it's our position, though, that the only violations that the board can hear involve the sewage in the basement. So that's violation number CF 2021-008608. We indicate that, to be fair, the board administration, we believe, and totally understandably, shows the violation notice on appeal as CF 2020-040197. So again, it's our position that the current appeal is too late to the extent that the appellant was intending to appeal that violation.
Mr. Router, the appeal number, the CF number that you gave initially, that's appealable. What number is that again?
The one that we think could be appealable, and it's oddly it's not included on the notice of appeal, is CF 2021-008608. That one, the current appeal, the one that's before you now, which was filed in March of 2021, that could be heard by the board, although again, actually, that could be heard by the board.
Okay, but she did not submit an appeal for that.
It's not clear because the documents that were attached to the notice of appeal weren't even really the violations at all. What the documents that we were able to see when I pulled them down off of the clips that were attached to the appeal are like basically a property served, which actually proves our case, among other things, but also like a title insurance form and things like that don't really, so it wasn't really clear what violation was being appealed, at least based on the documents that we have.
Okay, well, let's do this.
So I don't know what she was planning to appeal, but the only thing she could appeal is actually the violation.
Okay, I'm getting some background noise from someone, and maybe Ms. Ekwale, is there someone in your space who's working on something? I hear no one.
Mr. Yang has his audio not muted. If he could mute his audio, that would help.
Okay, Ms. Alfred, would you mind doing that, please?
I've tried. He doesn't have the option to mute on his little screen. I
Okay,
don't
we'll
know
take him
why.
out, put him in the waiting room, please.
Yep, I can do that.
Yeah, thank you. Ms. Esther Ikwale, which appeal or which violation are you attempting to appeal? Because it isn't clear from your paperwork.
Yeah, I think the one generally the issue to me was like the one is it like the sewage whatever from the basements.
Okay.
So yeah, and
But you didn't write that on your appeal application. Would it be easier if your daughter spoke on your behalf while you're present?
yeah, correct. I think that's why I requested, like, she's more knowledgeable to understanding these things better than I do.
But she can only speak on your behalf while you're on the call with us. You cannot send her to
Yeah.
represent you without you being present. Okay,
Okay, correct. I'm here. I'm here.
Okay, Miss Esther O. Ikwale, you're the daughter of the appellant?
Yes, I am.
Are you familiar with all the documents that were submitted?
Yes, I am.
Okay, the issue we're having here is that the paperwork says there's a 30-day window when you can appeal something.
Okay, yes.
That appeal was on the old violations, they were not appealed in time, so we can't hear those.
Okay, which I understand. I think when she got the first appeal for the 2020-2021, I think she still had tenants occupied, and she also had a property manager that she told also to like get the violations done, because I think we had like a fire extinguisher, some other like violations. But then we got the final notice again last year of February. And when I read it, I thought we were able to appeal again, because at that time, February of 2021, she didn't have any like tenants in that property again. And then she planned to sell it. And so when we made that appeal, it was for the one for 2020, 2021, which I didn't know it was past due to appeal. So I think the current one that she's allowed to appeal, we got the letter 2 weeks ago, which I didn't appeal for because as of now, she's no longer like the owner of the property because it was being sold. And for the violation for 2020, 2021, it was paid through, it's called, the settlement location is Germantown Title Company, which is why I attached the documents, because before she sold the property, they told her that she had to settle the violations, the previous violations, which she agreed to, and the money was deducted before she got the final money for the property.
What was the date of the sale, the settlement?
It was August 27th, 2021.
Okay, all right, I would think then, Mr. Marder, that this is a moot matter.
Well, yeah, and that's not what the city records are showing. I'm not sure what was happening here. It looks, the Office of Property Assessment records are still showing Esther Ikwale as the owner. So in that sense, she probably should, if she has sold the property, that would need to be updated. That's should have happened, but there's some delays with that. So she would need to follow up with OPA about that. But to the extent that if that's the case, and if she's saying that she's no longer the owner of the property, then yes, we would agree that the whole appeal is moot. In fact, I would note, by the way, just again, if you were called to testify, Mr. Augenbusch would testify that in fact the property was again, a re-inspection back in February, and then since then, let me go back to the original July violations. The city, the situation was so serious, the city issued an immediate cease operations, not an intent to cease. We shut it down immediately, and that's not for proof. The city witness testified that they were operating. Whoever was in there was operating an illegal hookah lounge, or bar, whatever, in the first floor of the property. Then we went out for re-inspection in February. The cease was not lifted. The cease has never been lifted because no permit applications to legalize anything were done. There were some fire code violations that were corrected, fire extinguisher stuff, things like that. And we were going to put that on the record. There were a couple things, I think 3 violations were complied. But as recently as this month, the inspector would testify that as recently as 2 weeks ago or less, no, actually, I think it was July 7th or July 8th, the club was back in operation at this location, and we reimposed the cease. So that was it was an illegal violation of the cease. But if the Iguales are telling us that they don't own the property anymore, and that in fact they're not contesting this anymore, then I agree. This whole appeal is moot. It should be because
thank you.
they're no longer the owners.
Okay, Miss Esther O. Ikwale, I need to swear you in. My apologies. Raise your right hand, please. Do you swear or affirm the testimony you have given and will give in this matter to be the truth so help you God?
Yes.
All right, thank you. You place your hand down. Well, let's do this then. Given all of that's been said, this note for the record, this is a moot matter. And so that resolves it for the Board of License and Inspection Review. Okay?
Okay.
All right, thank you very much.
Thank you.
Have a good day.
Thank you.
Okay, you're welcome. Have a good day. So what's next?
Okay.
It's my business.
Yes, sir. I can barely hear you, Mr. Browder. You may be excused.
Thank you.
Okay, what do we have next?
Next, we have case number 27, appeal number HA-2021-001220, 5703 Peralta Food Market, Inc., 5703 Elmwood Avenue, and they're represented by Joseph Vaccaro, Esquire.
Okay, and who's representing the city in this matter?
Good afternoon, Chairman Dejanay Davis on behalf of the City of Philadelphia.
Good afternoon. So I guess, do we have anyone here? Mr. Vaccaro, is anyone from his office present? Oh. Has there been any conversation with Mr. Vaccaro?
Yes, good afternoon. This is Joe Vaccaro.
Oh, Mr. Vaccaro, can you, good, okay.
Okay, I'm sorry.
Okay,
Which
alrighty.
case are we doing?
We're doing 5703 Elmwood Avenue, 5703 Peralta Food
Avenue?
Market.
No.
Yes.
And I have my client Ostari's phone is on.
Okay. Already. Will you be called an individual as a witness?
I was not planning on calling him, depending on what the testimony may or may not be.
Okay. Ms. Davis, you have any witnesses?
Yes, the city will be calling Jody Wilkins, but the city will also like to address the threshold matter before swearing in Ms. Wilkins.
Yes.
Yes, so the city will like to address the issue in terms of this appeal being untimely. The appellant had 30 days from the initial notice of this violation to file an appeal. Now that date of that notice was December 1st of 2020. However, the appellant didn't file this appeal until about February 2021, which is well beyond the allotted 30 days, almost close to 90 days from the actual notice date. And therefore, failure to timely appeal, the appellants additionally have waived any challenge to the notice and the tickets regarding sales to minors. And for that, the city will be asking that this appeal be denied.
Okay. Already. I have a couple questions for you with regard to that. Do you have the date of the initial violation?
Yes, if I may proffer, Jody Wilkins will be able to testify to the 3 tickets to sell the minors in question, in addition to the payment status of those tickets.
Okay, just one moment. Okay. If we're going to dismiss this for a lack of timely appeal, then I'd like not to get into extensive testimony from anyone. And so if you could just give me the dates that you have, that would be easier.
Okay, yes. So in terms of the tobacco sales to minor tickets, the first ticket in question the date of that ticket is January 14th, 2019.
Okay.
The second ticket in question, the date of the second ticket in question is February 20, 2019.
Okay,
And the third ticket in question is dated December 9th, 2019.
okay. And all
And
of
the
these,
tobacco permit denial letter is dated December 1st, 2020.
okay. And the,
And the appeal, the date on the appeal is February 27th, 2021.
February 27th?
Yes.
So my question,
21.
I'm
Okay.
sorry, Mr. Chairman, I just have a question on the city's position for clarification.
Yes,
Okay, thank you. Is it the city's position that my client needs to file an appeal of the underlying tobacco violations, the ones that she had described, 1/14/2019, 2/20/2019, and 12/9/2019, for us to proceed with this current appeal that we're arguing for today?
Your client had 30 days to appeal the denial renewal that was sent to them on December 1st, 2020. And that denial letter was due to the tobacco sales to minors.
Understood. If I may respond to the city's position, or does the board have some questions first?
well, Mr. Vaquero, if the denial letter is dated December 1st, 30 days from that date would be January 2021, correct?
Yeah.
And this appeal did not get dated until February 27th, 2021. 60
Of
days
course.
later.
Of course, and
Okay.
for the last year, if I may respond to that, for the last year, I've been representing countless store owners.
I'm going to object in terms of what the attorney is saying in regards to his
Okay.
other representation of
Okay,
business owners.
Mr. Vaquero, keep your arguments narrow based on this client.
Sure, this is the first time that the city is raising such an objection. During the time period of late 2020, early 2021, the city was still in the process of catching up on a lot of back work that the city had
Again, I'm going
not
to
been
object
doing.
to this.
Well, wait, Ms. Davis, I want to hear but Mr. Vaquero, keep in mind this. We aren't arguing the city's actions, we're arguing your client's action. And so why did not the client appeal before the time ran out?
Because of COVID. Everybody in the city, including the
No.
city
Be
operations-
more specific. Saying because of COVID is not adequate. Was he not conscious? Did he have some other issues? What was going on?
What was going on is that my client was in the process of catching up on a lot of back business that could not have been done during that time period. And that is the earliest time period that he was able to submit this appeal, when he was able to retain counsel, prepare the appeal, draft it, and submit it. And this is the first time that the city is raising
If I may, Chairman.
I'm sorry.
Let him finish, then I'll invite you to.
If I could finish my argument.
Please.
This is the first time that the city is raising such an argument, when the city itself has accepted the appeal, has processed the appeal, and the city could have taken whatever action during the last year and a half to strike or to dismiss the appeal. And for the city to first raise this issue on the day of the hearing is not right.
Okay, all right, Ms. Davis.
Chairman, if I may, whether or not this is the city's first time of raising this appeal does not negate the fact that even on the notice, it specifically states that the appeal must be filed within 30 days of this notice. That appeal was not filed. The business owner could have certainly filed this appeal prior to obtaining counsel and then obtaining counsel later in preparation for this hearing. And additionally, given the fact that they have not filed the appeal timely, that they have waived their rights to argue any validity in terms of this notice or the validity of the tickets in question.
The other issue, the other reality here is that the board gets to determine whether or not we will hear a timely or untimely appeal. So
I'm sorry,
aside from
can you say that again? You broke up a little bit.
what I'm saying is that the board itself gets to decide if in fact we will hear a timely appeal or not. And so it becomes the board's discretion as to whether we hear a untimely appeal. And so that's why I wanted to understand from Mr. Vaccaro, what was the circumstance with the particular applicant, the appellant.
Certainly the board has discretion, and the board has exercised this discretion countless times to permit the arguing and the presentations of these appeals.
Yes.
If I may,
And
Chairman.
has given us judgments on the merits.
Okay,
Better or worse.
Okay, Ms. Davis.
If I may, I will argue that the board does not have the authority to hear cases that are appeals that are untimely.
Well, okay, I mean, that's your argument, okay. But okay, all right, thank you. We've heard that, but in this case, with regard to this particular appeal.
I'm sorry?
I'm preparing to give you a decision. Okay?
Thank you.
I just want to make sure that I'm using the correct appeal number. With regard to HA-2021-001220, this was the set 5703 Elmwood Avenue. This one is particularly 60 days late, and so this is an untimely appeal, so we aren't going to hear this. Now, you can appeal this decision of the board, Mr. Vaccaro, if you choose to, but in this today, we are not hearing this matter.
Okay.
All right, it's an untimely appeal. Thank you.
Mr. Rostari, I'll call you this evening. I have 2 other cases before the board, okay?
Okay.
Thank you.
Okay, what's the next matter?
The next matter is, let me see, case number 28, appeal number HA-2021-001394, R&J Food Market, 3601 North 22nd Street, represented by Joseph Vaccaro Esquire.
Okay, thank you.
Good afternoon.
In the city, Ms. Vaccaro, how are you? Who's
How
representing the
are you
city?
again? Thank you.
Good afternoon, Chairman Woodson, Mary Costello on behalf of the city of Philadelphia.
Okay,
Mr. Jefferson's waving his hands.
Yeah.
yes.
Yeah, so with respect to the disposition of the case, is the board then dismissing that last appeal?
Yes.
Okay, thank you.
Okay, thank you. Sorry about that. Okay. In terms of R&J Food, Ms. Costello.
Mr. Woodson, this is a similar situation as the previous matter. The date of violation and refusal notice was December 1st, 2020. The appellants had 30 days to file an appeal, and an appeal was not filed until March 9th of 2021. It's over 90 days from the initial refusal notice.
Okay, so the appeal date or the violation date? Violation letter date is 12/1?
Yes,
And the appeal was submitted on what date?
March 9th, 2021.
Okay. So that's, goodness. Okay, that's actually 120 days, December, January, February, yes. Okay, over 120 days late.
If I
Mr.
may
Carroll?
respond.
Yes.
If I may respond, and just let the record reflect that in my office is Mr. Ahicar Mesa, A-H-I-C-A-R, last name Mesa, M-E-S-A. He's sitting in my office. He's a representative of the appellant R&J Food Market.
Yes.
And I would rely on the arguments that I have presented to the board with the previous case.
Okay.
This board
Right.
can hear this appeal, and it's within this board's discretion to hear the appeal. And the
Okay.
board should exercise its discretion to hear this.
Okay.
appeal. Thank you.
Okay, Ms. Costello, your argument is?
Our argument is that this appeal has been filed untimely. They had 30 days to file the appeal beginning on December 1st, 2020. It clearly states that in the notice, the refusal notice, and they waited until March 9th, 2020 to file their appeal.
Okay, all right, thank you. Well, based on the evidence that's submitted before the board today, this matter is an untimely appeal, so therefore it's being dismissed. Mr. Gray, I don't want to waste your time.
Thank you.
Okay. All right, what's the next case?
Next, we have case number 29. Appeal number HA-2021-001396, 55 Food Market the Third, 5467 Walnut Street, and represented by Joseph Vaccaro, Esquire.
Good afternoon again. And for the record, I have in my office Mr. Francisco Garcia, last name G-A-R, Gutierrez, I'm sorry, Francisco Gutierrez, G-U-T-I-E-R-R-E-Z, representative of 55 Food Market 3 Inc.
Okay, thank you. Who's representing the city?
Chairman Woodson, Mary Costello, again on behalf of the city of Philadelphia.
Okay,
This is a similar matter as to the two previous matters. Refusal notice was issued on December 1st of 2020. The appellants had 30 days to file their appeal, and an appeal was not filed until March 10th of 2021.
now the refusal date is February 1st, I'm sorry, December 1st of 20, and then the appeal is March 10th of 2021, correct?
Correct.
Okay, all righty. Based on this information, unless there's an argument that's substantially different than what we've heard already, is there any additional argument from Mr. Vaccaro or Ms. Costello?
I would rely on and incorporate my argument from the previous two cases. Thank you.
Thank you. Ms. Costello?
I would just reiterate the city's position that this appeal was untimely, that the appellants had notice of it, and they failed to appeal within the 30-day period.
Okay, thank you. All right, based on information that we have before us today, this is an untimely appeal, and so that we're dismissing this appeal. Thank you very much.
Thank you very much.
Thank you, Chairman.
Thank you.
That concludes my business before the board. May I be excused?
Yes, sir. Have a good afternoon.
Thank you. Do the same.
Okay, you have any voters that found our next case?
Okay, this brings us down to our last case, number 35. Appeal number HA-2022-002662, Bartlett C. Clark for 2326 Reed Street.
Okay, who's representing the city?
Good afternoon, Christopher Johnson for the city of Philadelphia.
Okay, Mr. Johnson, who's representing the appellant, Bartlett C. Clark? Anyone present who represents the interests of Bartlett?
Mr. Clark is muted.
Oh, yes, oh, okay. You can unmute Mr. Clark.
I asked him to unmute. Okay, he's unmuted.
Yes, I'm here. I have no representation. I'm representing myself.
Okay, Mr. Clark, would you raise your right hand so that you may be sworn, please? Do you swear or affirm the testimony that you give today be the truth so help you God?
Yes, I do.
Okay, thank you. Again, I think we asked this person early on a previous inquiry, but this property is owned by you in your name personally, individually?
Yes, it is.
Okay, all right, thank you. Mr. Johnson, are you prepared to proceed?
Yeah, the city is prepared to proceed.
Yes, please do.
Okay, this is a appeal of a notice of intent to cease at the property located at 2326 Reed Street in the city of Philadelphia. The reason for the cease was that they did not have the proper zoning for the occupancy. There are currently either 10 or 11 individuals living in the single family dwelling, and there's numerous other conditions that would be hazardous given the occupancy. And I have one witness I'm going to present today. It's Inspector Emerito Alvarado.
Okay, Mr. Alvarado, if you unmute yourself so that you may be sworn.
Okay.
Raise your right hand. Do you swear or affirm the testimony that you give today be the truth so help you God?
I do.
All right, thank you. Mr. Johnson?
Mr. Alvarado, can you please tell us where you're employed?
I'm presently employed at East District. I'm a fire safety code inspector.
And have you had a chance to inspect the property at 2326 Reed Street?
Yes.
And I'm gonna share my screen if it please the board.
Yes, please.
Mr. Alvarado, on what day did you become aware of the property at 2326 Reed Street?
I was there on June the 14th, 2022.
And what led to that inspection?
It was a special inspection regarding I think it was a rooming house or an investigation.
And I'm going to be showing a number of pictures that are within the city's packet of exhibits. I'm currently showing page 1. Can you please identify what we're looking at?
That's a 3-story house. The address in violation, 2326 Reed Street.
And is that the middle structure in the row houses?
It will be the one with the beige vinyl siding and the 2 air conditioners on the window.
I'm going to scroll down and can you tell us what's on page 2?
The same thing, the front of the property.
Now, when you did your inspection, what did you find?
I found a couple of violations on the property regarding fire extinguishers, some electricals. Actually, there were it's a single family dwelling, but it had 11 occupants at time of my inspection. I noticed 11 occupants and about 12 beds.
I'm currently showing what's marked as city exhibits at page 3. Can you tell us what this is?
That is a picture of the basement where they had a weight workbench, washing
Are there any
machine, dryer.
violations indicated in the photograph?
Let me look at my other computer like that. I can see it bigger. I was just showing, the basement at that time. I think there was a light bulb missing or open junction box into ceiling.
And this is page 4. Can you tell us what we're looking at here?
That's where the meter box was. There was another junction box that was open, wires exposed.
And is that a violation?
Yeah, you can't have no wires exposed.
How about the picture at page 5?
That's some type of a light switch that didn't have a light switch cover on it.
Is that required under the code?
It's not a requirement, but it should have a cover on it.
I'm now showing what's marked as page 6. Can you please tell us what we're looking at here?
That's a open junction box at the ceiling, wires exposed. It should have a cover on it.
Is that a fire hazard?
Yes, could be.
How about page 7?
Same situation. It was another junction box with the wirings in it, exposed wiring with I guess it was a bedroom sheet tied to the ceiling at that side.
And page 8?
I was just showing the heating system, hot water heater system.
Was it operational?
Well, at that time, they did have hot water, but the heater, it's not a heating season, so I didn't check it.
And page 9?
Page 9 is just showing some stuff that was in the basement at the corner.
To show that the property was occupied?
Yeah.
Okay. How about page 10?
Page 10 was another room area or another part of the basement where it had stuff belongings.
Okay. And page 11?
Page 11 was a door that had a sign on it, keep out, you will be dismissed if caught in here. Apparently there was items stored behind that door. I think one of the occupants opened the door and just I asked them, to see if there was anything in there that was hazardous.
Did you look in?
I did.
Okay.
The tenant opened the door for me.
How about page 12?
Well, it's just, hold on 1 minute, the lights went out. It's showing just that, there's a bathroom, one bathroom.
Is this on the first floor of the structure?
No, that's the second floor.
Yeah.
And if you look at the wall on that photo, apparently where the window is at, that's where the ladder, a hangout ladder is installed, apparently.
What would that ladder be for?
It will be an emergency escape route or a fire ladder where people could climb out.
In case of a fire?
Yeah.
Okay. How about page 13?
Same thing, just showing the ladder.
And 14?
It's just showing the conditions of the bathroom, that's all.
Wait, is this the same bathroom or a different bathroom?
No, that's the same bathroom.
Okay.
Well, no, actually, that's a different bathroom.
Where was the other bathroom?
I think that's the bathroom on the third floor. Correct. Third floor bathroom. Sorry
thank you.
about that.
And how about page 15?
That was one of the bedrooms. I think it was the third floor bedroom. Ceiling tiles and the frame was falling.
And page 16?
Page 16 is showing 2 bunk beds in 1 bedroom.
And this is 17.
17 is showing probably the same bedroom where they're, when they hang clothes.
Now, page 18, is this the same bedroom?
No, that's a different bedroom. That's the front bedroom on the third floor. Showing 2 bunk beds.
I'm going to move on to page 19.
That is in the living room where there was another outlet cover missing.
So the outlet cover was missing. Is that a violation?
Technically, no, but
Could it be a hazard?
could be a hazard, yeah.
And how about on page 20? What is this photograph?
That's where I was showing the extension cords being plugged into an outlet. Air
In the
conditioner.
middle of the photograph.
Yeah. Yep.
I'm going to go to page 21. What is 21 indicating?
Well, I'm just showing that there's a fire extinguisher there. It's not inspected. It's not tagged. It's one of those portable fire extinguishers that you buy in Home Depot.
Would that be compliant with the fire code if they had the zoning for a rooming house?
No.
How about page 22?
Page 22 is showing one of the bedrooms where they installed the same hanging fire ladders, but they never finished the job. The walls exposed and open.
And page 23, I believe that's the same room.
It's showing another bedroom, another bed.
I'm moving on to page 24.
Just showing air conditioner in the window. I was hooked up.
And page 25.
Showing another bedroom with another bed, another air conditioner.
So we've been keeping count. How many bedrooms is that so far?
The property has 5 bedrooms, actually. 3 on the second floor, 2 on the third.
And I'm on page 26. What does that indicate?
Another bunk bed and another bedroom.
And 27.
Same thing, another bunk bed.
And 28.
Another bedroom with another bunk bed.
And I'm gonna move on to 29. What is 29 indicating?
It's showing you the extension cords being used throughout, and then the cover to the heater missing.
Are there any violations of the Philadelphia Code that are exhibited by this photograph?
The extension cords.
And page 30?
That was just showing a deteriorated wall.
And what room was that?
Can't remember what room that was.
Was it on the first, second, third floor? Do you know?
Can't remember.
Okay. How about page 31?
Showing another different, another fire extinguisher at another location.
Would this be a fire extinguisher that would be code compliant?
Not necessarily, not under, well, it's one of those over-the-counter fire extinguishers that you buy at the big box stores.
But it wasn't inspected or tagged?
No inspection tags on it or anything.
How about page 32?
That would be the same, another different fire extinguisher at the corner of the kitchen cabinet.
How many
First floor.
kitchens are there in the premises?
Just one.
And how about page 33?
I took a picture. This was showing, I guess, who was responsible for cleanup or chores at the property.
Is this a list of all the residents?
Yes, it was.
It looks like, how would you characterize what's on the board? What is it?
Shows a couple of names, phone numbers. I guess it's rules and house rules or house chores rules that
The chore chart.
Yeah.
How about page 34?
This is showing when I was there, they were saying they were recovering addicts. So I took a picture of the 12 steps, which they, go by looking, reading.
And page 35?
Same thing was, can't really see it, but I just took a picture of it. House rules. Those were the house rules. I guess they were implemented either by the owner or the tenants.
And page 36?
Just showing the kitchen with a stove.
And 37?
Page 37 is showing the front porch where this is where I had some concerns regarding some items. If you look at the very end, there's a propane tank, there's a washer, combustibles on the porch, which was a little bit hazardous, could become hazardous. And I think there was a little grill in there somewhere too.
And page, what am I on, 38?
That's just me showing, walking in to the property, showing that it has a living room, dining room, and the back door is the kitchen.
Excuse me.
Page 39?
Showing a smoke detector. Where the location was on the wall. That's another smoke detector.
And 40, that's, what is that?
Another smoke detector.
Are the smoke detectors operational?
Yes, they were.
And I'm showing you what's marked as page 41 in the city's exhibits. What is this?
This is the notice of violation that was sent out to the owner to be corrected.
And does this notice list all the violations that you uncovered in the property?
Correct. Yes.
And what other action did the department take as a result of your inspection?
Well, as a result of my inspection, the department stated that we had to give him an intent to cease because there was no rental license, there was no zoning or certificate of occupancy for the dwelling unit that's being used as a recovery house.
And what was the date the cease was supposed to occur?
It was supposed to, let me see, I have to look into my records.
Well, I'm showing what's marked as page 49 right now. Does this help?
Okay, yes. It was gonna be ceased on June the 24th, 2022.
And what was the cease imposed on June 24th?
The cease did not take place due to the owner putting in an appeal, an appeal on the intent to cease.
In your opinion, as a code inspector, are there life safety issues that exist at the property?
Well, the cease was going to take place because of no zoning. He did have smoke detectors on every floor level. He did have extinguishers, but they weren't approved extinguishers. The cease was going to be taking place due to the overcrowding of 11 occupants. For licensed inspections, you only allow 3 occupants that can live in one single family dwelling. He didn't have a zoning for recovery house or for 11 occupants.
At this point in time, I'm gonna refer back to Mr. Clark's argument in his emergency appeal petition, where he was saying he was applying to be classified as a recovery house by the state. And I'm going to share now. Can you see my screen?
Yes.
Yes.
Okay, hold on a second. Let me go. Fine. Hold on. I need to stop.
Are you finished with your witness, Mr. Johnson?
No.
Okay.
I took the liberty of consulting with the Department of Drug and Alcohol Programs for the state on recovery house licensing because Mr. Clark was suggesting that if he got this licensing from the state, he'd have some sort of reciprocity with the city. However, clearly one of the requirements for getting this license, and I'm going to scroll down, I'm going to ask the board to take judicial notice that one of the things that's required is something in the middle of the page called attestation of compliance with zoning requirements. And what the state is doing, and the board can take judicial notice of this, it's a matter of public record on the state's website. They're asking applicants to become licensees as a recovery house that they attest that they are compliant with all applicable zoning requirements, local zoning requirements. Now I'm going to ask Mr. Alvarado, is this property compliant with local zoning requirements?
No.
And I'm going to further ask again, Mr. Alvarado, shouldn't the owner of the property have complied with the zoning requirements before putting 11 people in that building?
That is correct. You must obtain the zoning before you can do anything.
And what's the current use registration permit on the property?
Single family dwelling.
Is it a single family dwelling right now?
It is a single family dwelling. The problem is we have, hold on, it's that the lights are on timers here. On motion, bear with me. It is a single family dwelling. The issue here is the 11 occupants living in a single family dwelling. The city of Philadelphia only allows 3 occupants unless he can get an approved zoning for 11 occupants.
So in order to operate such a occupancy, he would have to get permission from the city and from the zoning board. Is that right?
He must get a zoning permit, approved zoning permit. Yes.
I'm going to ask that the city's exhibits be admitted to the record at this time. And just one follow-up, the single family dwelling is only for the occupancy of people related by blood, right?
Correct.
And that's defined in the code?
Yes.
Okay. I have nothing further. And can the city's exhibits be admitted at this time?
That's so admitted, yeah. Mr. Clark, do you have any cross-examination of the inspectors based on his testimony? We will give you an opportunity to explain yourself later, but do you have any questions of the inspector?
I do not.
Okay, thank you. Anything else, Mr. Johnson?
Excuse me, Mr. Chair, can I just ask one question? This is Mr. Watson.
Sure. Yes, sir.
He made a statement that only 5 occupants can be in a property, even with 5 bedrooms. Only 3 folks could be in with 5. Just clear it in my head.
Okay.
So if you have a single family dwelling with 5 bedrooms, it has to be in related people living in the property. This property is a 5-bedroom unit with 11 unrelated properties. So it's a single family property being used as a recovery house, which are non-related occupants living in it.
Thank you, Mr. Chair.
All right, thank you. All right, Mr. Johnson, do you have any further witnesses?
No, the city has no further witnesses.
Okay, Mr. Clark, share with us your situation, your position here.
Well, my position is I am the owner of the property. It is being used as a recovery house. I'm recovering myself, 30 years sober. It was done for me. I've been trying to help people for a few years here. But you're 100% correct. I mean, I know the zoning is not proper. I tried to obtain zoning 2 years ago, 3 years ago. It was denied. I've been operating like this the whole time, but we are now in violation. I'm going to, empty the property out. I need some time to relocate occupants to places where they are safe. I have a responsibility to them in recovery. These are folks that really don't have anywhere to go. They've burned all their bridges. They're trying to get back on their feet. They've all been into treatment facilities and now have come out and come to me. And families don't want them. They don't have credit. They can't get a place of their own. It's just going to take me a little while to get everybody out of there.
Then how many occupants do you currently have, Mr. Clark?
Right now, there are 10 people in the property.
Okay, and given that you were denied zoning a couple of years ago, why haven't you begun moving people out now, before now?
This is the service I'm providing for these folks, and it's something I got into, and I just couldn't stop doing it for them.
Okay, all right. Now I noticed that there's been some extensive plumbing and electrical work some time ago, I suppose. You have permits for all that work?
I bought the property like it is.
Okay.
The electrical, I've done no electrical work in the property, but I have complied most of those violations that were noticed on there.
Okay. Anyone have any other questions?
If I may, I would just ask Mr. Clark how much time he's looking for.
I don't need, I can take about a month to get everybody out of there and relocated. Some guys can probably leave, in a week, but there's going to be some folks, it's going to be a little more difficult for me to get them out.
Okay.
I have a question, quick question, Mr. Chair.
Yes, please.
Of Mr. Clark. Mr. Clark, are you a licensed addiction therapist or counselor of any kind?
No, I am not. My manager is a certified recovery specialist.
So you have someone who works with you who is trained in recovery
Yes, ma'am.
care. Okay. But thank you very much. That was my only question.
I have one more question for Mr. Clark, if it pleases the
Yes.
board.
Yes,
Have
please.
you tried to get when you applied for the zoning, did you apply for a special accommodation for that recovery house, or was it just a straight zoning application?
It was a straight zoning application, yes.
And I guess I would say the city is not opposed to 30 days stay of enforcement in this case, but if you're willing to give it one more try to apply, there could be a possibility that you would get a special accommodation. Let me just give you the code section from the zoning board. That is, hold on a second.
Wait, let me get a pen here. I want to write this down.
We lost our appellant.
It's chapter 14 -303 6.
I'm sorry, I missed it. What was it?
14-303 6D.2.
And what is that?
Well, if you were going to reapply for zoning, you may request a special accommodation under that section. I'm not sure whether it would be granted or not, but I would just say if you were applying, that may be something you could look at. I don't have any more questions though.
Okay.
May I speak?
Yes.
That was something I planned on trying to do. I just wanted to comply with the CSOPs. I don't want everybody to just get thrown out. I'm going to try to relocate people and try to get this done. I'm currently talking to an attorney about zoning, and I wanted to continue to do this. I believe it's extremely important to these folks that need it. It was done for me almost 30 years ago, and I believe in it. I've stayed sober all this time. I had an alcohol problem, and all these folks got similar problems. We've had a tremendous amount of success in our house. It's not always so out there, and I believe in what I'm doing here. I really want to continue to do this.
Okay, Mr. Clark, do you live in that residence also?
No, I do not.
Okay, alrighty. The city has proposed, as offered, a 30-day stay of enforcement. So we're going to bring this matter to a vote. Get the appropriate glasses here. With regard then to appeal number HA-2022-002-002662, Bartlett C. Clark, 2326 Reed Street, City affirm 30-day stay of enforcement.
City affirm with a 30-day stay of enforcement.
City affirm with a 30-day stay of enforcement.
City affirm 30 days stay of enforcement.
City affirm 30-day stay of enforcement.
Okay, thank you very much. I think that concludes our list for today.
Thank you.
Is that it for us today?
Thank you
you
for
need-
your consideration.
Thank you, Mr. Clark. Appreciate it.
Thank you. Mr. Alfred, is that it for today?
That is it for today, yes.
Okay, thank you very much, everyone. I'd ask the board just to hang on for a few minutes. Everyone else, please have a good evening.
Thank you.
Thank you.
Okay, good evening.
Have a good evening.
Thank you, Ms. Rapp.
Thank you. And I have to apologize to Mr. Reuter. His arguments are too good to not get them on the record.
Get every word.
No
That
need to
is so true.
apologize. We just need to be able to hear anyone.
I
Thank you.
understand.
Okay. Just want to Ed, if we could go back to this whole issue with tobacco, because it's going to come up a lot more. And we haven't paid as much of attention to it as we should have in the past.
Which issue? I'm sorry.
The issue of timeliness.
Yeah, well, you know, to be fair, the Board of License Inspection Review is only given the authority as it's set out in the code. It doesn't have authority to, or, you know, to apply its own discretion when something is like totally factual. You know, now in those untimely appeals, if a person were to come and make an argument that even though the notice was sent, that for some reason that the board may find legitimate, they did not get notice until, let's just say, within the 30-day window of their appeal, then, you know, as a fact, you could find that the notice was ineffective and that the notice wasn't served until that date. And then you would have jurisdiction. But aside from that, you know, it disqualifies the board from hearing a case because they just don't have jurisdiction over something that wasn't timely appealed.
Now, I suppose if the appellate is also, say, deathly ill or had to leave the country for some reason beyond their control, you could also consider those items, right?
Well, here again, you know, I think that that's a humanitarian statement, but in truth, if they know about it, then they need to direct somebody to do something.
Okay.
But
I thought it was interesting that all three were being handled by Mr. Vaccaro, and all three were filed around the same time, well beyond the 30-day period. So I think the backup was more in Mr. Vaccaro's office than in his client's business papers when he was trying to assert that his client was delayed. It was the same, basically the same appeal form, all filed within maybe 24 hours of one another. I think the problem was his.
Okay. I'm just asking because one of the things we haven't watched closely is the appeal dates, and particularly individuals. Now, when there's a corporate matter, that's different. A complicated case, then you have attorneys arguing 5 points.
Yeah, I just, if I can, revisit two little things.
Okay.
Okay, one was number 20, and he was an electrician, Brian Monroe.
Yes.
Now, you know, the violations that were issued in that case were issued to the property. They were not issued to Brian Monroe as an electrician. In other words, there was nothing against his license. And the permit that he was issued to him was really never the subject of a violation. It was still open. I mean, nobody issued a violation notice against it.
But I thought the city lawyer said the only issue we're dealing with today is the appeal of the electrical license permit.
I know.
So, but he's the only one who can close out an electrical permit as an electrician.
Well, I know what he said, but, you know, and I saw the notices of violations that were attached to the, you know, to the appeal. And I went on, you know, online on Atlas. And in fact, you know, a permit had been taken out by Mr. Monroe, but the permit was open. And that permit, if there was a violation against Mr. Monroe, it would have had to be against his license because he has no authority over the property. He can't.
But he has authority to close it. He's the only one who can close the license out, though.
Well, no, that's correct. He can close out the permit, but there was no violation against him, his license for that. So, I mean, I was really a little confused about that.
Yeah, actually, they should have resolved that before bringing it to a hearing. They should have just, you're muted, Roger, you're muted.
I mean, I agree, certainly agree with you on that.
And he has a responsibility to call for either an initial or a final inspection, and only he can do that, not the owner. So I agree with you, the violation was written to the property, but the reference, when you read the appeals that were attached, they also included in there that, and I noted that he was, as an electrician, he was exceeding the use of the permit that it was issued for. He was exceeding that permit.
Roger, I don't dispute anything that you're saying, except the fact that, you know, he doesn't own the property. He doesn't have like, you know, any possessory right legally. So this thing really, you know, was like kind of, you know, meaningless because it's not affecting his license, and you're absolutely right with respect to the inspections.
Right.
But, you know, the inspector in this case, who he corresponded with, should have written a violation against his license.
Right.
And did not do that.
Right.
If he wanted
Now,
to
the
hold
other
it
thing,
down, yes.
I need some reaction from the board. A person who shows up in the underwear to a hearing, what can I say?
Oh my God. Oh my
Oh.
God. I wanted to say something so badly because we have had people walk into the Court of Common Pleas. I mean, you'll remember Ed in front of Judge Rogers when the gentleman basically rolled out in his gym shorts after a long night's sleep. You know, I mean, I could not believe he was sitting there in that t-shirt. And
Mr. Woodson, I thought you was going to say something when he first got on the camera.
yeah, I started to send you a message, Mr. Woodson, to ask him to please come back a little bit
Yeah,
later after he had put a shirt
shirt
on,
on.
but I decided not to say anything. But
And I
yeah,
think-
appalling.
Is that legal?
What
Is
did
that
his shirt
legal
say?
for us to send them away?
Absolutely.
Yes,
You can,
yes.
yes, you're in
Yes.
you're in an official court
Not
hearing.
legal.
No.
Yes,
No,
you're in an
I-
official court hearing.
Not legal, but we can ask for that request. And I think we
Right.
should, going forward, we should ask them to put on a shirt. We'll come back to you.
Yes, well, that's what I'm
Yes.
saying. Not leave and not come back. But
Right.
as the chairman indicated to him, he was in an official proceeding.
Yeah.
And there is an appropriate way to appear when you're in an official proceeding. Just
Correct.
like the guys that, you know, I know people say you shouldn't say anything about people wearing their hats, but I think it's totally inappropriate for someone to be in a courtroom with a peak cap slapped on backwards or,
Yeah.
you know, to the cock to the side or whatever. You're in an official hearing.
Mhm.
So you wouldn't go in front of a judge that way. We're an administrative board. You're looking for something to, you know, protect yourself. I would think you'd want to represent yourself in a little bit better.
It would
Well,
seem-
Ed, you have one other thing?
It would seem to me that, you know, a regulation, you know, would be in order with respect to, like, you know,
Appearance.
the propriety of, you know, your wear when making an appearance before the board. But outside of that, unless they, you know, showed up in a way that basically was offensive to the law, like, you know, naked.
Naked.
It was offensive to us. We were
Naked.
offended.
I could have been offended. Yes, I mean, really.
I mean,
Mrs. Jefferson.
I don't really think you can just dismiss them, you know, summarily.
Okay.
No,
Mr.
no, and that's
Jefferson.
not what I was suggesting. I was suggesting
I
that
just
perhaps you
wanna
would
say-
consider.
Mr. Jefferson, thank you for preparing us for One Red Lion Road.
Yeah.
But you talked
Oh,
about
God.
the two attorneys, but you didn't talk about that third attorney. That was a surprise to us.
Well, he just, you know, sent that motion to quash today.
Yeah.
Oh, okay.
Okay.
But that notwithstanding, I mean, with respect to that particular matter, you know, and you hit the nail on the head. It was moot. And I think that, you know, it was good that somebody called for a vote on that, because
Right.
I know that there's going to be an appeal, but the appeal is not going to proceed. You know,
Okay.
he can go back to the Court of Common Pleas and ask for relief there from the court's decision.
Okay.
Not to say that he would get it, but, you know, with respect to standing, standing is pretty wide open.
Okay.
Historical Commission, Art Commission, you know, it's a little bit more restrictive when it comes to a permit for a particular use or for a particular, you know, construction at a particular property. Standing is a very big issue. And it really only applies to somebody who is directly affected by, you know, whatever it is, the issuance of a permit or a license or whatever.
Well,
So-
you can see though, when you look on the map, that all of those homes directly across the street from there are going to be directly affected. That's going to be a horror for those people who live off Red Lion. I mean, I'm not talking about the legality of it, obviously,
No.
because the zoning permits it.
I
But
feel
all of those
sorry for
all of those homes are going to be impacted. They're
Yeah.
probably going to sustain damage over time from all of those trucks and things going back and forth 24/7. There's going to be noise complaints and lots of, you know, noise violations and things like that. So I was a little torn about the standing issue, even though I knew that basically that they're not the RCO. The standing issue had been addressed at the zoning
Yeah.
hearing, but I don't see how in a way, I don't see how they can't have standing,
Oh,
because they're going to be.
They sit borderline. They sit on the borderline, you know.
No, but they don't, you know, I mean, I can tell you right now, they do not have standing.
No, I understand that, Ed. No, I understand that. I'm just saying
Oh.
the city's going to face other kinds of problems as a result of, making that agreement, because those people are going to be damaged, and then the city is going to have to be, well, not the city, UPS is going to be getting sued, I'm assuming.
Yeah, but
What was the
Beverly,
use up there before? That's always been.
That's what I was gonna say. What was there before?
there were two things there before. Island Green, the golf course was there. And then after Island Green Golf Course, a pharmaceutical company bought it and only used a portion of the property and kept a 9-hole golf course.
Yeah, so no, I mean, that's very benign, I mean, a
Yeah,
golf course, nobody's for the most part being hurt by that, but you're talking about massive trucks up and down Red Lion, and UPS is gonna be working 24/7. It's just gonna be abominable for the people who live there.
I know,
They
but
do better with the housing development there. They do much better.
They've been trying to build that facility.
And I have a real quick
Say that again,
question for you.
two
Say that
two
again.
legal issues, but go
Built
ahead.
that facility for 15 years in different places. I've been to hearings where there's been 500 residents and 10 business agents, and we walked out.
Oh,
Yeah.
Because there's 500 trucks 24/7 going in and out that place.
yeah.
Just real quick on the last one we just had, the last case, when
Yeah.
we was talking about the recovery system and all of that.
Yeah. Mhm.
Just curious, just real curious. You have all them folks in that house, and it's my understanding there should be some type of sprinkler system.
Well, if he
But
gets
but there's nothing in
correct.
the report. We can't say anything about it, correct?
Correct. No, but what will happen if he applies to make it a multi-person recovery center? That will change the fire code requirements for that space.
Right, that's right.
So he has to have
We
certified-
can't issue him violations, for something that he's not zoned for.
Yeah, in a single family dwelling, you're not required to have a sprinkler system
Right.
in your
But
house.
that would jump in. Once he got a permit to do
Absolutely.
multifamily, it would all become a requirement.
And
I have a quick question. Number 3, Sherelle, I didn't note what the results were. Can someone give me that?
That was one of my questions as well, Roger. I
Was
wanted to
moot.
get the decision for number 3.
the property was
that it
sold.
was moot. The property was sold. Yeah, sorry, Ed.
That's the Equale.
Yes.
So the
Yeah.
property, I saw that the property was sold. So what was it? Moot?
It was moot.
Moot.
Oh, okay.
And number 13, the board decided that they was going to grant the motion to quash, right?
Yes.
Yes.
Well, I mean, the guy never entered really as a party in the case, but that was great because it helps the reasoning, which is.
Is it number 13? No, that's the David Orfanini, right?
Yeah, no, it wasn't.
Right, but the motion to quash was filed by Mr. Phillips, Michael
Yes.
Phillips.
Exactly.
Okay.
So
Now-
I'm confused with that. Is that a dismissed or? Because I
So
never
when you
had.
quash some,
Moot.
when you, yeah,
Moot.
it makes it moot, basically.
Thank
When you
you.
quash it, you just stamp it out. I just wanted to make one comment about number 3, that some of the violations that were being referenced in Len's argument were not attached to the information that we received from Deborah.
Correct.
I had completely different violations. I never
Right.
saw anything about sewage in the basement.
Right.
I think everything I had was fire code violations. So
Correct.
when I was trying to follow him, I had a little.
Yeah,
trouble.
she did not appeal the appealable violations.
Right.
Okay,
Appealed the
okay.
old violations. And as it
Okay.
turns out, the house had already been sold, so all of it was moot.
It was
What
over.
happens with the router, he's good, very, very good, but he adds a lot of
Yes,
information.
yes,
Sorry.
we know.
He's the only guy that puts on a case without a witness.
Right.
And wins.
And wins. Very good at that.
And wins.
He likes to talk himself, but
Yeah, you'll always learn something.
You do.
Len needs to be in a university because he would
Yep.
be an excellent law school professor.
Yes,
Yep.
he would.
Yep.
that
Thank you,
last,
everyone. If there's
Thank you,
nothing
Mr.
else,
Chairman.
no, that last appeal, just to let you know, and Roger and Beverly know, he worked for L&I.
Yeah.
Oh, he did?
I wanted to say that
Yeah.
he's an
Still currently-
inspector. He's an
He's
inspector.
still currently an inspector. Am I right, Sherelle?
Works for the construction.
And not only him and his son.
Yeah.
Clark,
Yeah.
Him and his son.
Yes,
Right. It's 2 Bart Clarks. Him and his son.
right. That's
he
right.
knows this thing.
Oh, yeah, he
Very
knows.
well, very well.
Yes, he does. He knows.
Just because
He
you know
is-
what the law is, don't mean you ain't trying to break it.
He is he
Beverly.
is a building inspector. Yes, he is, and has been for a long time.
But in
Ah.
CSU, contractual services unit. But-
Yes,
Yes, yes.
So number 10 was moot complied, but I don't think a time was ever attached to that. Oh, I'm sorry, not number 10, number 16, 16.
It was 3 o'clock.
3 o'clock. 3 o'clock.
Okay, all right, because that's what I have written down, but I didn't hear that.
Yes, and
3 o'clock.
Beverly and Mr. Wilson, I'm gonna take care of Mr. Yang. He's already called me 3 times while we was in the hearing.
Okay,
You better give him his money back for that vacancy.
he needs to stay in the hearing when he's there. When he leaves, you lose.
Yeah.
You move, you lose. So
Yeah.
Yes.
Great job as
everybody.
Thank
always.
you, everybody.
All right, good night,
Have a
everyone.
great
Take
evening.
care. Take
Thank
care.
you.
Good night.
Night.
Sherelle, you got
No, Roger.